Oh, yeah, no.
If I may. No, we're actually, I'm sorry, we're on the record now. Good morning. We were waiting for Senator Holden, who, our fifth board member, who unfortunately is stuck in traffic. I understand there's an overturned big rig, and so it does not look like he will be in for at least the first case. So we're going to proceed, unfortunately, with a four-member board, at least for the first case of the morning. So it is Thursday, August 10th, 2017. We are meeting, the hearing board is in session. We are meeting in the hearing board room in the district headquarters in Diamond Bar. The time is 9:15. We have two matters on calendar for this morning, for today. The first is Beta Offshore, case number 5855-6. And who is here for that matter?
Stacy Pruitt and Nancy Feldman for the district.
Thank you. Mr. Tether, would you like to proceed to take a seat? Okay. Since we have two cases, let me just ask you, Mr. Tether, how many witnesses do you have and how long do you think your affirmative case might be this morning?
Two witnesses, Chair Prusak, and I think about a half an hour.
Okay. And Ms. Pruitt, do you have any witnesses today, and about how long do you think?
Yes, we have one witness from the engineering who's a staff member, and we don't intend to call her unless, of course, the board has questions for her.
Okay. So I anticipate that we will not hear the second case till at least 10 o'clock, and maybe after that. Okay, so first I'm going to ask, well, let's put it on the record. Who is representing Beta Offshore today?
Ivan Tether for Beta Offshore,
Thank
Chair
you.
Prusak.
And for the district?
Stacy Pruitt and Nancy Feldman for the executive.
I don't know if you have your mic on.
Stacy Pruitt and Nancy Feldman for the executive officer.
Thank you. And for the record, welcome, Ms. Pruitt. I will ask all witnesses to please rise to be sworn in at this time. Please raise your right hand. Do you promise to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Mr. Tether, your opening, please.
Thank you. Good morning, Chair Prusak and hearing board members. Beta Offshore, or Beta, operates 3 oil and gas producing platforms that are located 9 miles offshore from Huntington Beach. Today we're petitioning for a short variance for the engine that operates Platform Eureka's center crane. The center crane engine D90, is a 195 brake horsepower internal combustion engine. Eros Environmental, Beta's contractor, source tested this engine on June 13, 2017. While Eros earlier suggested that the engine passed, final results first reviewed by Diana Lang late Friday morning, July 14th, show that engine D90 failed its source test for VOC. Ms. Lang is Beta's manager for health, safety, and environment. The applicable emission limit for VOC is 250 ppmv at 15% oxygen. Engine D90, the center crane, emissions tested at an average of 282 ppmv for 2 duplicate samples. The daily excess emissions are low. They're 2/1000ths of a pound daily. Just after noon on that same day, Friday, July 14th, Ms. Lang reported a breakdown to the district under Rule 1110.2, notification number 479358. Just a little later, Ms. Lang contacted me by email requesting assistance, help, with filing a variance petition. At about 4 o'clock that afternoon, Ms. Lang notified District Inspectors Martha Thomas and Nydia Ibarra, as well as District Engineer Maria Vibal, about the results of the source test. On the next district business day, which was Tuesday, July 18th, Beta filed the petition that is before you today. On July 19th, the hearing board granted Beta an emergency ex parte variance for engine D90 so that it could continue to operate for certain purposes. Beta couldn't have reasonably expected that engine D90 would fail the source test. Beta performs routine and regular maintenance on the engine. Beta tuned up the engine on December 21st, 2016, and changed its oil in September of 2016. Engine D90 passed its last periodic source test, which was in June 2014, with a reading of 229.9. We could call that 230 ppmv, but still 20 ppmv below the limit. Platform operations are highly regulated, and the Department of Interior's Bureau of Safety and Environmental Enforcement, referred to as BESI, carries out frequent on-site inspections. The crane operators monitor engine operation both before and during crane operation, and mechanics address any abnormalities. And Beta changed the oxidation catalyst on D90 in early May. The center crane is needed for the following tasks: to transfer chemicals to the lower decks, where they are used to inhibit scale and corrosion, and for well treatment; to perform lifts that are normally handled by the west crane, which is inoperative, awaiting installation of a new, very clean Tier 4 engine, and that installation is expected in mid-September; to access the shipping pumps, to serve as the backup crane for offloading passengers and food for platform personnel, and also unloading them; for handling lifts that are associated with well work when the rig is over the west well bay, and also to essential to participate in installation of the new Tier 4 engine to the west crane. There is now one other operative crane on the platform, and there will soon, in September, be a second, but each crane has a different reach, and all three are required to fully service the platform. Not being able to use the center crane would adversely impact the productivity and the safe operation of the platform. If the work that relies on the center crane were postponed, there would be increased risk of equipment failure and safety or environmental incidents such as leaks or spills. Further, failure to maintain equipment could be an additional violation of permit conditions E2 and E8, which require that equipment be maintained to ensure its proper operation. Beta had no notice and no reason to expect engine D90 to fail the source test. Beta is replacing 7 crane engines on its 3 platforms with low-emitting Tier 4 engines. They'll have a limit, as do 3 that are already installed, of 30 ppm VOC instead of 250 ppmv. The platform Ellen crane engines D87 and D91 have been replaced, and platform Eureka engine D88 will be replaced next month. Beta's contractor retested engine D90 on August 8th, 2 days ago, and Beta anticipates compliance. Beta requests that the board granted a short variance to continue being able to operate the center crane on platform Eureka. That concludes my opening. Thank you.
Thank you, Mr. Tether. Before we move on with Ms. Pruitt's opening, we have an email that the board received. It starts with Clerk of the Board. It's dated Wednesday, July 26, 2017, to Ms. Feldman and Mr. Tether. I'm going to mark that as Exhibit 1, and essentially it takes the interim variance off calendar and change the regular to a short variance. We're going to mark that as Exhibit 1.
Thank you.
Ms. Pruitt, your opening, please.
Thank you. This is a 0.002 pounds. This is 0.002 pounds of VOC a day, 9 miles offshore, for a very short period of time, so that the petitioner can replace the old engine with the new one that will pollute far less and assist to promote a healthier air quality. Based upon this, the district is not opposed, subject to the conditions submitted to the clerk and the presentation that will be made to the board.
Thank you. Mr. Tether, did you have a
Oh, I'm
preliminary
sorry.
matter?
Only that I have the conditions that Ms. Pruitt references, and I will provide them to your clerk.
Let's do that now, so we can take a look at that. We've received proposed short variance conditions, and we're going to mark that as petitioner's exhibit number 2. Why don't we take 5 minutes and review those conditions before you present your first witness, Mr. Tether? We're off the record.
Thank you.
We're back on the record. Mr. Tether, you can present your first witness, but having read the proposed short variance conditions, I was wondering if it can be explained during testimony how the 180 days provision in condition number 5 fits within a short variance.
Shall I respond to that?
If you can respond to that now, that would be helpful.
Well, my witness might also, but basically, my witness will respond to the actual time required, potentially, for installation and reasons for considering installation of another engine before, if the one that's before the board passes. But as far as how that fits within a short variance, we have some hope that we might have final results within 45 days and that we will pass and therefore no longer need a variance. But I would even ask the board to consider whether they, at this hearing, would like to calendar a regular variance, or would you rather wait for 40 days or so and have us contact staff and request calendaring of a regular variance if we have not achieved that somewhat optimistic timing of receiving conclusive test results for the test that was performed 2 days ago.
I think it's best to proceed with the hearing today and reach our final decision and to set a regular variance hearing, because it would be the preference of the chair, at least, to make sure that when we hear cases, they can be completely and with finality be completed within the time frame of whatever is requested, whether it's short variance or regular variance.
We would be very happy to have a regular scheduled today rather than wait. So thank you.
Okay.
And we'll bring up the actual mechanics of the timing during testimony.
And that will be important.
Yes.
Okay. So you, with that, why don't you go ahead and proceed with your first witness?
Yes, I'd like to introduce Beta Offshore's first witness, Diana Lang, who is the Manager for Health, Safety, and Environment. Ms. Lang, could you please spell your name for the record?
Diana, D-I-A-N-A, last name Lang, L-A-N-G.
Ms. Lang, have you taken the oath?
Yes.
And briefly, how does your work relate to what we're going to present the board with today?
I oversee the HSE department for Beta Offshore, which includes source testing and all air compliance.
Did you witness the source test on Tuesday?
Yes.
Thank you. First, is Beta Offshore's crane engine D90 out of compliance with the VOC emissions limit from requirements and also from requirements in district rules and permit conditions?
The final test results that I reviewed on Friday, July 14th, 2017, show that this crane engine D90 out of compliance with the provisions, rules, and conditions. We have some questions about this, but we're optimistic that the retest will show that it passes. The D90 test results, the average of the two were 282 parts per million. Actually, one result was in and one was out. But
Thank you. And could you briefly review for the board the rules and conditions that are out of compliance because of this source test failure?
Yes. The equipment description in Section D of the permit states the VOC limits of 250 parts per million by volume by day at 15% O2 for internal combustion D90. In Table 2 of District Rule 1110.2, little d1b, the VOC limit is stated there at 250 ppmv at 15% O2. This is applicable to D90. Rule 203B states that equipment not be operated contrary to the conditions specified in the permit to operate. And the final source tests show violation by D90 of the VOC permit and rule limit. Rule 2004 F1 requires compliance with all rules and permit conditions. And the final source tests show violation by D90 of this rule. Rule 3002 D2 requires compliance with all applicable provisions of a Title V permit. The final source tests show violation of D90 of this rule. In the permit, condition E2 requires maintaining all equipment to ensure proper operation, and the results exceeded that one. Permit condition E7 require maintaining all equipment to ensure proper operation and compliance with permit limits. Final source tests show violation by D90 of the VOC limits stated in the permit and rule 1110.2 D1B. Permit condition E8 require that all equipment operating under the reclaim program shall comply concurrently with all provisions of AQMD rules and regulations, except those listed in Table 1 of 2001 for NOx reclaim and Table 2 of Rule 2001 for SOx reclaim sources. The final source test results show violation by D90 of these VOC limits in the permit and Rule 1110.2 D1B. And last, permit condition K8 require compliance with all regulatory requirements and all permit terms and conditions. Final source test results show violation by D90 of VOC limits stated in the permit and Rule 1110.2.
Thank you. Is there a regular maintenance and inspection schedule for this equipment?
Yes. So Beta inspects and maintains this engine daily before use. They do monthly, quarterly, and annual inspections in accordance with the API Recommended Practice 2D, which is the guidance document for the operation of offshore cranes. And this is the guidance document that Department of Interior, Bessie, holds the platform to. It's quite rigorous, and they're out quite often. I would say a couple times a week, not always just to look at cranes. They look at all the safeties on the platform, but they're out all the time. The engine was tuned up in December, as Ivan mentioned, and the oil was changed in September. It's at roughly 250 hours of operation. And we replaced the catalyst in early May.
Thank you. Is engine D90 currently or in the last 6 months under variance coverage?
Yes, the ex parte emergency variance was granted by the board on July 19th of 2017. And there's been no other variance for this engine within the last 6 months.
Has the district issued any notice of violation about engine D90 within the past year?
No.
Has Beta received any complaints from the public about engine D90 within the past 6 months?
No.
Has Beta complied with the conditions from the emergency variance?
Yes.
And could you explain how that compliance occurred?
We've limited the use of that crane to the purposes that were stated in the condition 1. We keep daily records of the crane operation, the hours of operation, the fuel use, and the VOC emissions in pounds per day. And we've calculated those VOC emissions according to the condition number 3.
Does Beta Offshore see any need to modify or add conditions?
Yes, we've submitted an exhibit of proposed conditions for this requested variance. We'd like 2 additional uses. First, to handle the lifts with the well work when the rig is over the west well bay. And second, to assist in the installation of the new crane engine for the west crane. Forgot that one, so. And also, we request that the petitioner shall report results of the August 8th retest of the Eureka Center Crane D90 for the VOCs within 60 days of the retest, which would be on or before October 7th of 2017. And then if the retest fails, the petitioner shall initiate the replacement of the Eureka crane engine within 180 days of commencing operation of the west engine crane.
To your knowledge, has the district concurred in these changes?
Yes.
Thank you. So, is this source test failure beyond Beta Offshore's reasonable control?
Yes.
And why would you say that, based on what?
Well, we did not expect the failure. I described the inspection and maintenance program that we have for the cranes. And because we put the new catalyst in, we believed that we'd done everything to get a passing result. Operators maintain the engine prior to and during crane use. The mechanics address any abnormalities if they observe anything. And the prior source test was 229.9 ppm, so it was passing.
Thank you. What would be the harm to Beta Offshore if immediate compliance were required?
So if we couldn't access the center crane, deferring maintenance that relies on the center crane would affect our reliable and safe operation of platform equipment, and we couldn't possibly install the new crane engine for D88 without the center crane. This
I'm
would
going to,
yeah,
go
okay.
ahead, please.
Let me finish. This would adversely affect a substantial portion of the monthly gross revenues produced by Platform Eureka and the loss of royalties to the Department of Interior, Bessie, which receive 12.5% of the gross revenues.
I'm going to interrupt the flow for a moment and ask you to discuss why we are asking for 180 days if the retest fails to initiate installation of a new Tier 4 engine on the center crane and replace engine D90.
Sure. So on Eureka, there's 3 cranes. One is, empty right now because we're waiting on the crane engine. When they take a crane engine, when they take a crane out of service, they work on the boom, the long part, and the east crane, which is the one that's used the most for offloading passengers and gear and stuff like that. That one is scheduled for the next engine because it needs repairs on the boom. And the boom repairs, they disconnect it, they send it in, they send it to a manufacturer that will certify the welds and, fix it. And it could take a month or more. And so while it's down for boom repairs, it's a perfect time to put in an engine. So the east crane was the next one that we were going to do right after we finished the west crane. But it passed its source test, so I understand why you'd want us to do the center crane next. But if we could have the 180 days, we could do the east next and then do the center. Probably what would happen if we had to, I know it's confusing, but we would change the engine on the center crane and still fix the east crane boom. It's just downtime. It's like unnecessary downtime if we don't have to. If we could use the downtime to fix the east crane boom and do the engine at the same time, it's less downtime on that crane.
Is the, I think earlier you touched on the importance of each crane. Could you review that again?
Well, there's little crossover between what each one can do because of the reach. So the center crane, you can't see as well for the personnel and the boat. You can't see the boat from the center crane. Not sure what I was going to tell you about that.
Could you also just review the 3 crane engines and their status in terms of engine replacement and what the preference you just stated?
Right, so the preference was finish the west crane and then do the east because it has other issues that we want to address with the boom. And then we would do the center. And so we were going to do 4 cranes this year and 3 next year. So we would finish the 4th crane this year, which could happen as early as September. That was going to be the east crane because that one has collateral repairs that we need to do. But if we have to if we don't pass the retest, if we have to do the center crane next, we'll do the center crane next. We'll get that engine exchanged. Then we'll fix the east crane boom. And then next year, under the new budget, where we have 3 cranes budgeted for next year, we would do that 5th crane.
That would be which crane?
It could be the center crane. If we could do that one,
But if the center crane fails the source test that was just,
right, then we'll do that one next. And we could start it as soon as September if we had to.
okay, thank you. Would there be any benefit from shutting down engine D90 as compared to the cost of the shutdown?
There would be no benefit.
And why is that?
Well, the excess emissions are only 2/1000th of a pound, 0.002. They're emitted 9 miles offshore. This is roughly, like if you were to empty a WD-40 can and take 250 squirts, it would be 1/250th of a WD-40 can. It's very little. Any amount of excess emissions should be addressed, but the economic and safety issues call for continued operation of D90. And I mentioned we can't install the other crane engine without it.
Has Beta considered shutting down or curtailing operation of engine D90 instead of needing a variance?
Yes, but the economic and safety issues already discussed, and the small amount of excess emissions make the shutdown or further curtailment inappropriate. Plus, having 2 cranes out of service would trigger intense scrutiny by Bessie.
Remind us again what Bessie is.
Department of Interior, Bureau of Safety and Environmental Enforcement.
Thank you. Are you reducing emissions to the maximum extent possible?
Yes. The excess emissions are only on average 2/1000th of a pound of VOC per day.
How will you monitor these emissions during the variance period?
We will calculate them in the same manner as the excess emission calculations were done for the variance petition. The calculations will be based on the VOC concentration from the engine D90's June 13th, 2017 source test.
And how will Beta return engine D90 to full air quality compliance?
We retested the crane engine on Tuesday morning, August 8th, and we're optimistic that this retest will show compliance.
And if it does not?
Then we will initiate replacement of D90 with the Tier 4 engine. As soon as we get the West Crane D88 replaced, which we expect to be mid-September.
So then you would start the process toward
Yes.
replacement of the center crane, the
Yes.
D90 engine. Could you just briefly describe that?
What the timeline would be?
Yeah, just you would order,
Well,
whatever the
yeah.
timeline is.
So we have budgeted for 4 cranes this year, so it has been, I'm not sure if it's been paid for, but the fabrication could begin as soon as September 18th. It takes approximately 5 weeks to build the engine. They build it in Chicago, then they ship it to California. It gets all the aftermarket emission equipment added to it. And the install could begin optimistically by November 10th. There's other adjustments that get made to the crane before they can put the engine in, because the torque converter on the older engines operates at a lower, slower idle, and the new engine's much faster. It's like a Ferrari, so they have to retool the torque converter. That's not something you can do in advance. You have to take the crane out of service to do that, so we can't do that in advance.
Okay, thank you.
Sure.
That ends our direct testimony.
Thank you. Ms. Pruitt, do you have questions for Ms. Lang?
Just a couple. Is D90 how you get people on and off of the platform?
It's not the customary one. I would imagine they could do it if they had to. It would require more effort, I think. I'm not sure, honestly, if they can reach where the people are.
And why will it take 60 days to submit source test results?
I was using the allowable amount that's in the permit, which is, and the rule, it requires 60 days from the source test date. The samples are analyzed at a third-party lab, and it takes a few weeks for them to produce the results to the source testers, and then the source testers evaluate the results, and they have a peer review process. And when I've gotten preliminary results in the past, I think the guy's made a mistake in his math like 3 times in a row. So during peer review, they catch his mistake. So that's why I've had this false hope sometimes that I pass, and then upon final results, they're like, oh, you didn't pass, because they caught a math error. So I want it to go through all the peer review steps to get the right answer. It's quite possible we'll get the results sooner, but no later than 60 days.
And can you explain with some specificity, what would deferring the maintenance do exactly?
The maintenance on replacing the crane engine?
Yes.
If we defer the maintenance, it would allow us to work on the east crane, which has other mechanical issues that we want to address first. That's basically.
Nothing further.
Thank you.
May I have a moment to redirect?
Yes, why don't you do that before the board asks their question?
Thank you. Ms. Lang, just with regard to the 60 days for the source test results, is it possible to expedite the results? And if so, do you have any thoughts on that?
Well, I kind of do have thoughts on that. I'm not a big, if you want my honest opinion, I'm not a big fan of expediting, because when you put people in a rush mode, they often hurry and make mistakes. I don't know that would happen, but I would rather people take their time and do it right. There's a lot riding on this, and I don't want a simple error by a lab tech to mess up our results.
Thank you. That's all.
I just wanted to ask a couple of questions, because I honestly, I'm a little perplexed, given the testimony, as to why the decision was made to change the request from a regular variance to a short variance. We've heard testimony with regard to what you just, and I had that same question, why not expedite the retest results? And that doesn't seem to be the preference. But yet that puts us out 60 days. And the preference that you testified to as to going with the east crane before the center crane would then put you out another 180 days, and not within the short variance period. So can you explain a little bit more for the board what the thinking was? First of all, let me ask you, why are you optimistic, was the word that you said, that this time it will pass, whereas it did not pass on the first go-round?
Well, so on the day that we tested the center crane, we also tested the east crane, and those are identical engines. The east crane gets used a little more, but the results by the same test method, 3 out of the 4 results were below the 250 VOC compliance limit, and one of the test results was above. There was a 39% variation between those data points, and there's a provision in a protocol that says when there's that much variation that you could dismiss one of the results, but there was, I think, maybe some disagreement which result should get thrown out. So we are retesting, but I really believe that we're going to pass. I mean,
But there's been no changes to the engine since the last test or anything of that nature, is that correct?
well, we put in the catalyst insert that is the one that's permitted. It's not a replacement. I mean, it is a replacement in kind. It's not one where the vendor in a previous crane that had failed had said, oh, this one should do the same job, and it didn't. It was worse. This one is the correct one, and since we did have one passing result, I believe we can get 2 passing results.
In the petition on page 5, we're reminded on number 11 that there are 3 other cranes that have not passed recently and that have been replaced. So, given that, are those engines the same engines as the center crane on Eureka?
They are, but 2 of those engines that didn't pass had a catalyst that I believe wasn't the right one. I mean, it was a part that was supposed to be the same, but I think it had a different temperature requirement in order to perform, so.
Okay, but the other 2 were the same.
So 2 had the catalyst issue and 1 was the same, yeah.
2 had the catalyst issue. Okay. If this board asks you or requires in a variance to perform the center crane replacement first, is that acceptable?
Yes.
And you said that the earliest that the installment could begin would be the November 10th? Even that is pushing the short variance.
Well, we
timing.
can take it, excuse me, we can take it out of service as soon as we're done with the west crane, we can begin the center. So getting it operational is different from taking out of service where it would stop emitting.
Okay. And that will be in September, is that correct? Is that when it's currently scheduled, is
If we
the west
needed
crane is for
to-
September?
Yeah, if everything goes well with the west, it would fall into place in September.
But it's very likely that it would fall into place within the 90 days of the short variance, is that correct?
Yep.
Okay. I just had one other question. On the proposed short variance conditions in Exhibit 2, just so for the record, is number 1, is that all of the possible and current uses of this crane?
That's all we could think of.
Okay, thank you. Mr. Camarena, did you have questions? I saw you did.
Yes, I did. First of all, Ms. Lang, you described some math errors by someone. Was that at the lab that does the analysis or the people that take the sample?
The people that take the sample.
And they've done this 3 times. Are they still certified to do this work?
Well, yes. I mean, the guy that's collecting the sample does preliminary, he looks at the data and did some preliminary. Most of the time he's had issues with the O2. He was looking at like the wrong O2. I mean,
Okay. It's my understanding that it's the firm that does the testing and not the individual that gets certification. So
yeah.
that's something the district might take a look at. With respect to the 2,000.002 pounds per day, that's assuming 24-hour operation, is it not?
No, it's a 1 hour a day average.
Okay. How did you arrive at that average?
Well, I took the crane hour reading from a year and a half ago. I started with January 1st of 2016, and then the hour meter reading at June 30th, and divided by that many days and got an average of 1 hour. And then I've been tracking it, and I have a exhibit if you care.
I don't think I need to look at that level of detail, but let me ask you, over that period of time, what was the greatest number of hours that it was used on a given day?
I don't have that with me. I would say A really big day would be 4 hours if the rig required work.
Okay.
But on average, it's in the last, well, since June 30th, the highest day is 1.1 hours. Most days are 0.2, 0.3, 0.1, few days in a row of 0, 0.4, 0.7. It varies, but
In your direct testimony, you testified that the catalyst was replaced in early May. That was early May of this year?
yes.
And why was it replaced?
Well, we weren't experiencing any back pressure on the catalyst, so it was mainly precautionary for the source test.
Thank you.
Ms. Byrd?
Just one question follow-up, and I wasn't sure if I understood what you're saying. Initially, you had an expectation that you passed. That was based on the technician? Is that what you're saying? Mm-hmm. Okay, before it had been taken to the lab, and
No.
this is just based on his,
He had received the results,
He was-
and he did the calculation. He corrected to the O2, the 15% O2, but I think he made a mistake with the correction. So his preliminary estimate, if we passed or not, was he said it was looking good. But then when I got the final report, it showed that one of the results was too high, which skewed the average.
is that typically the way it's done? I'm not familiar with so typically after you get after he's done the testing, he comes back and he gives you that preliminary result, and is it typically correct, or is it just?
So what the lab will do, the sample's collected into a canister, and they do their method extraction to solubilize everything that's in that container. One of the things that can skew a result are carbon solids that could drop in there. And so they're not VOCs, but yet they get solubilized and they contribute to the overall number. So that's why two samples collected at the same time could be slightly different, if any of that comes in. But the lab will give a result and they'll say this amount of O2 was detected in the sample. It might be 18%, it might be 14.4, whatever it is. They just give that result to the source testers, and it's their job to correct that 14.4 to 15. And if he does that math correction wrong by just a little bit, it can skew that result.
And so when do you expect the results from your from August 8th test, did you say?
I would say probably approximately 2 to 3 weeks from like next Monday, because truthfully, the samples are still on the platform right now because they're doing 4 cranes in a row. So they started on Tuesday morning and they won't finish till tonight.
Okay.
And then they'll drive back tomorrow with their,
So in about a month, you would have the results?
I think I'll have them sooner, but I'm thinking 3 weeks, but
Okay,
not sure.
thank you.
Dr. Lerner?
You referred to a test in June 2014 on D90, and it was at rounding off 230, with the limit of 250. That's about 92%, 23/25. So that was 3 years ago. Can you tell me how frequently you actually check this to see how well it's performing?
According to the rule, it's every 3 years. So that would be the last time that we looked at it. And one of the test results of the duplicate came in at 227, so that's right in line with the previous test. And the engine, I know it's 3 years older, but it's about the same. I mean, these are reliable IC engines. But, one of the test results was higher, so. But that's where the duplicate questions come in.
Thank you.
Any other questions, board members? Just for the record, obviously Senator Holden has joined the hearing board, but because Senator Holden missed the first hour or so of testimony, He will not be voting, but will be present on the board.
I understand what you're saying, but I got a whole file on Beta Offshore.
I'm sorry?
I have a whole file on Beta Offshore, and I read the report very well, what they're requesting, what platform they're asking to be reconsidered on. They got about 3 platforms going out there, and they asked for a consent item a long time ago, and I'm not understanding where they're coming from at this point in time either. So anyway, I won't comment, but problems, as you know from the report, there's a whole file on them.
I appreciate that, Senator Holden. Unfortunately, we need all voting members to be present for the testimony during each hearing. And I do understand that there was a terrible accident. Unfortunately, that's the way it had to work today. Mr. Tether, your next witness.
No further witnesses, Chair Prusak.
Ms. Pruitt, you are not presenting a witness, is that correct?
That is correct.
Okay. Any member of the public wish to be heard? Seeing none. Mr. Tether, would you like to make a closing?
I would. Thank you. Beta reacted quickly to unfavorable source test results that they received just before noon on July 14th of this year. The source test failure was unexpected. Beta performs regular maintenance, has real-time monitoring daily whenever the crane is operated by the crane operators, as well as we've discussed, favorable prior source test results. So on this basis, plus the fact that Beta replaced the oxidation catalyst recently in early May, Beta was not unreasonable in failing to anticipate the failure. Continued operation of the center crane powered by engine D90 is important for maintenance operation that help to ensure effective, safe, and environmentally sound operation of platform equipment, which also maintains compliance with permit conditions E2 and E8. And operation will be essential to installation of the new Tier 4 engine to engine D88, the West crane. Their excess emissions are 2 1,000ths of a pound per day. They retested the engine D90 2 days ago, and for reasons brought forth in testimony, anticipate compliance. Beta requests that the board granted a short variance to allow limited continued operation of the center crane on platform Eureka. Beta also requests, pursuant to District Rule 303G, that the board adjust the minimum daily excess emission fee of $186.03 to reduce this amount to 25% of that amount, or $46.51, beginning as of the date the board granted the ex parte emergency variance. The calculated fee under Rule 303, Table 1, for that amount of excess emissions is 1 cent. In addition, given this very small amount of excess emissions, we request that if the source retest passes, that no excess emission fees be charged and the payments be refunded. Thank you for this opportunity to appear and to present this case.
Thank you, Ms. Pruitt. Your closing, if you choose one.
May I have one moment?
Yes, we'll go off the record. We're back on the record. Ms. Pruitt, you're closing.
Thank you. The district's position is still, we do not oppose the variance, considering that in condition number 5, we would suggest that the 180-day limit be changed to a 60-day outside limit for the source test results to initiate the replacement of the center crane should they fail the retest. And the petitioner has already agreed to appear for a regular variance if they fail.
Thank you. Board members, before we have discussion on the various findings that we need to make, I wanted to restate the issue that I have with the request before us. The issue being, this case was originally set as an interim and a regular variance. It was switched by the choice of the petitioner to a short variance, yet what is proposed to us under the short variance conditions today would under no circumstances fit within the 90 days. And in particular, when we talk about 90 days, it's not 90 days from today. It's 90 days from the ex parte relief, which was back on July 19th. So we're talking about a 90-day that essentially would only last through October, approximately October 19th. I haven't calculated what 90 days is, which would allow only condition 4 to fall within it and not condition 5. The reasons that were given for why petitioner feels that this case fits within short variance was an optimism in passing a test, which 3 other cranes have failed. Petitioner was surprised that the East crane passed, and these engines are all similar. So I don't believe that we can hang our hats on a short variance based on the passing results from Tuesday's retest. So I'm troubled, and I wanted to say why that is. There's very different notice requirements, as this board knows, for a short variance versus a regular variance. Short variance requires only 10 days posted notice, which is outside this room. A regular variance requires 30 days published notice. I think it's dangerous to set precedents where petitioners come before us knowing that if it goes one way, it's not likely at all to fit within the 90 days, but just to say, we'll come in for the 90 days with the 10-day notice, go for 90 days, and then at that point, if we need to, we'll do published notice. That seems to defeat the notice requirements of the Health and Safety Code, which give an exception to those series of variances that only go for 90 days, and puts the public in less of a position to be notified properly of something that will take more than 90 days. So my feeling, just to, before I wanted to hear from others, my feeling is to, I think that the findings can be made, but only if we can fit these conditions within 90 days. And so I would request that the petitioner, instead of number 5, waiting until the East crane is done and giving either 180 days or 60 days, which falls outside of the short variance, to require that that center crane be taken out of service once the West crane installation is completed. That would be my preference. Other board members want it? Mr. Camarena.
I'd like to first of all point out that in Exhibit 1, there's an email from Ms. Feldman wherein it's stated that the district agrees that the appropriate variance to seek in this matter is a short variance. With respect to the optimism, I'd like to point out that in May of this year, the catalyst was replaced, and following that, the preliminary test, as reported to the petitioner, was that things look good, that it was okay.
Anyone else have anything to say? Any thoughts? Ms. Bird, did you have thoughts?
It troubles me a little bit too, and that's what I was thinking when I saw this initially. But what I thought was, I might just, if I'm understanding this correctly, and there's a lot of dates and crossover here with the cranes, but why include 5 can we just take 5 out? Because if it fails, they will need to come back, and let them come back without telling them that will give them a certain number of days.
Is it that your suggestion is then they would have to come before us for a regular variance, and at that time, we would make a decision as to
Right.
whether it
right.
makes sense to allow them to replace a separate, the east crane first, or the west, or the center crane? Is that?
That was what I was thinking, just in general. If they really believe that it's going to pass, then it wouldn't even be an issue. And if it's not an issue, then the short variance would be sufficient, and it sounds like that's what they're expecting. To me, it looks like number 5 was just kind of put in there, and it could not have been, but kind of put in there at the last minute just to cover whatever. Let's just cover everything, even though it doesn't fit at all. And they expect that this will go, and if it doesn't go, then they'll just have to file for a regular variance. And I was thinking not even including number 5 at all.
What about the history of this petitioner, and this being the 4th crane within a relatively short period of time, with similar engines, same engines, having to be replaced due to failed source tests? Do you have thoughts on that?
I do.
Oh.
In their place, well, they did replace that catalyst, and they did get a false positive result that it passed. Given that they replaced the catalyst, I think that kind of takes away the history of the other engines that have failed. That's my thought.
I don't have an issue with beyond reasonable control. I don't have an issue with the fact that the petitioner expected and had good reason to expect, given the source test of 2014, given the preliminary results this year on this particular engine, given that they had just replaced the catalyst in May. That I don't have an issue with. I don't have an issue with any of the findings. I do have an issue with the fact that petitioner chose short variance relief and then presented irregular variance conditions. And before we opt to change or not to change or take out condition 5, if I may, I would like to ask for the position of the district on taking that out, since the district seems to have first agreed with the 180 days and then requested a change to 60 days. I don't know if the district has a position, excuse me.
I'll field this one. Thank you, Ms. Prusak. The district does not object to taking the condition out at all. I do agree that it is a prophylactic condition designed to address future possibilities. I failed to notice that it was 180 days. I would never have agreed to a condition that goes beyond the short variance time frame. So I accept responsibility for that. But other than that, I think the only objective in putting that in was to anticipate the unlikely event that the source test would result in another failure. The reason why the district did agree that a short variance was the appropriate relief in this case is because it was presented to us as extremely unlikely that this engine would fail again, given that it passed 3 out of the 4 runs, and that 4th run was considered by Beta Offshore to be an outlier that should not have been considered in the result. There is and continues to be a good faith disagreement between Beta Offshore and the district as to whether or not that run should have been included in the result. So this whole seeking of a variance is because the district is insisting that the source test failed.
Thank you, Ms. Feldman. Anyone else have any thoughts overall or want to address each of the findings? Board members? I think we are. The findings, not a motion, just the findings.
Since nobody will jump in, I'll just start. Okay, petitioner for variance is or will be in violation of a rule. Petitioner is in violation currently based on their last source test, a failure of exceeding the limit of 250 ppmv. Their last test showed them at an average, I think it was 282 of 282 ppmv. And so they failed that test, and they are in violation. This is kind of tricky, though, because they don't expect to be in violation once they're done with that, once they get the new test results. But currently, based on the test results that just took place, that they have the final results for, they are in violation. I believe it's due to conditions beyond their reasonable control, and that is based on the fact that they do have regular maintenance. They follow the maintenance for this type of operation from the Department of Interior. They do maintenance before they use the equipment. They have monthly, quarterly, annual inspections. In anticipation of their source tests, they change the catalyst out. They did an oil change in September. They did a tune-up in December of last year. So I think that it was beyond their reasonable control. Their last source test was about 230 ppmv, and so they had an expectation that they would be able to pass this source test. So I think it's beyond their reasonable control. Arbitrary taking, unreasonable taking of property. I believe that to not allow them to operate or would defeat some of the things that they're trying to do, including replacing engines that are higher polluting with lower polluting engines. I believe that taking and closing would be without a corresponding benefit. This one is pretty clear. It's like 2,000 ppm of VOCs per day. So closing the taking would be without a corresponding benefit with that minimal amount of pollutants. And for the location of this platform offshore, the applicant has given consideration to curtailing the operations. There's really no other curtailment. It's so small of amount at this point, there's really no other curtailment that they can do that would reduce the pollutants. But if they curtail their operations, they also cannot complete the installation of engines. They can't continue to operate the rigs or the platforms, excuse me. So I don't think that there's much that they could do there. They have considered the reduction of excess emissions, and once again, the excess emissions are so small that I would say that they're negligible. Then while the variance is in effect, they will be monitoring, and they have been monitoring
They have followed the conditions that were given to them in the ex parte that required monitoring and calculating the emissions based on condition number 3. And have those available for the district should they want them. I think that overall, this variance will allow them to move forward and to get them to a point of having new engines, much lower polluting engines, and that for those reasons I mentioned, I think that I can find good make all the findings to issue this variance, short variance.
Thank you, Ms. Byrd. Anyone else have any thoughts or additions to the discussion? I would just say that I'm convinced that if whoever makes a motion takes condition 5 out, that this is an appropriate case for a short variance. Anyone want to make a motion? Ms. Byrd.
I will. In the matter of Beta Offshore, case number 5855-6 for the facility located at OCS lease parcels P300, P301 on the Outer Continental Shelf. I move that we issue this short variance with from the rules that are listed in the petition on page 4 as they pertain to exceedance of the VOC limit of 250 ppmv. It would be for the equipment that's listed on page 3. Reclaim device D90. And it would be with the conditions as in Exhibit 2, deleting number 5 and renumbering 6 and 7. And it would be with excess emissions of approximately 0.002 pounds per day of VOCs. And it would commence today, no, this had an ex parte. So it would continue through, I don't have a calendar, but it would be 90 days from October 19th. From July, from July 19th. So that's approximately October 19th, but let's see. Is that 90 days? Are there any 31 days in there? July had 31 days, so it'd be October 18th? August has 31 days. Okay, it's October 17th? I need to do that little thing on my fingers to remember.
Why don't you make the motion as 90 days? And
90
and
days
supposing that is the date you say, but that 90 days rules.
Okay. So it will be 90 days from when the original ex parte was issued on July 19th. And I think that's the end of my motion.
Did you state the address? I think you did.
I stated the facility address, yes.
Okay. Is there a second? I'll second the motion. Discussion on the motion, board members. Seeing none. Mr. Camarena, how do you vote?
Yes.
Dr. Lerner, how do you vote?
Yes.
The motion passes 4-0. The short variance is granted. We have another request on the table, and that is with regard to fees. And if you could at this time, because I know it was a complex two-part request to waive or to reduce fees and then potentially waive them altogether. So if you can restate that and then your basis for that, Mr. Tether, I would appreciate it.
Certainly, that was in my closing. We request, Beta Offshore requests that the board adjust the minimum daily excess emissions fee, which is now $186.03, to reduce this amount to 25% of that amount, which would be $46.51. And we asked that it begin as of the date the board granted the ex parte emergency variance. We pointed out that if you look at Rule 303, according to the Table 1 in Rule 303, calculation of the excess emissions is 1 cent. We also requested that, given this very small amount of excess emissions, if the source retest passes, that no excess emission fees be charged and that payments be refunded. That's a separate request.
I believe that's the way it generally works. Is that correct?
I'd be happy to concur with that.
If there are no excess emissions by the end, then I believe it gets refunded.
We'll certainly accept that.
Is that, I'm sorry, Mr. Chatter, you have more on that?
No, that's it. Thank you. Chair Prusak.
I would like, oh,
Do I?
I do too. Go ahead.
Do
No,
I
no.
pronounce your
Ms.
name?
Berg.
Do I pronounce your name correctly?
Prusak, yes.
Prusak.
Yes, you are correct.
Thank
Thank you for asking. I had a question for a witness, and I don't know, Ms. Bird, if you
My
did.
question was, he's asking for a reduction. Did I hear exactly a persuasive argument for why?
Well, simply that if you calculate it according to another table, Table 1 in Rule 303, the excess emissions fee would be 1 penny per day. So $46.51 seems adequate. Hopefully that, as has been recently discussed, hopefully that is a null point because we'll pass the source retest. But that is a separate matter.
Okay. I typically, okay, that's fine. If that's your argument, I'll take that.
And I should probably, for the record, I may have misspoken because I can't speak for the district or how emissions fees are calculated, but if there is on record a failing test and then a passing test at a later date, I'm not sure that those generally get refunded. No, and Ms. Feldman is saying no to me. So forgive me for misspeaking.
So that would just cover the period from, well, I guess it'd be from June 23rd through the last Tuesday, the 8th of August. Is that the belief of the board and the district?
Well, it's your request.
Thank you.
Okay. I did have one question, if I might be able to. I'd ask my fellow board members. The question I wanted to ask was, what are the revenues of this facility, either on a daily basis or on a monthly basis, or however they can be given to the board? Would board members allow an opening of testimony for that question? Okay. Then, if I may ask, if you have a witness who can answer that question.
Yes, I believe. I'm pushing her button. Yes, I believe Ms. Lang can answer that question. Thank you.
So the gross revenues are 2.7 million per month.
Thank you. Anyone else have questions for Ms. Lang while it's open?
May I request Ms. Lang's notion of what the expenses are?
Okay, so that is the revenue, gross revenue number?
Yeah, that's gross revenue.
Okay.
Expenses are quite near that.
Can you generally describe the expenses? I'm sure there's staff and so forth.
Well, we have 99 employees. There's, I know the operating fees, I know that there is profit, but it's not equal to 2.7 million a month.
Thank you.
Okay, so we don't have an estimate on profit? But it is profitable?
We're in the black.
Okay. Any other questions, board members? No. Mr. Holden?
The issue's been resolved, but the legislative intent was that this agency would operate on fee-for-service. You give it all away, it's got to be funded. And that's the program. They're in violation, they pay. That's the intent.
And I, just for the record, I appreciate that, and I think it is appropriate for the senator to weigh in on fees at this moment. Maybe not vote, but to weigh in. Anyone else have any thoughts? I think my thought is that $186 a day does not seem to be otherwise inequitable to me, which I think unreasonable hardship has not been stated. So I think there's only two under 303M. There are only two bases for a reduction in fees or elimination of fees. And I'm not sure that I have heard sufficient testimony or information or argument that $186 a day is sufficient inequitability or inequity. I don't know if anyone else has any other thoughts. Ms. Byrd.
And I guess that was what I was trying to get to. Mention was made by petitioner of section G, but M gives us the discretion to reduce it, and we only have two ways to reduce, or two basis on which to reduce it, and that would be unreasonable hardship or financial hardship. And I don't believe that there's financial hardship or anything unreasonable. And unless my book is not updated, I have $181.49 a day as the minimum. So I don't think that's I haven't heard an argument to tell me that that's unreasonable.
And as for the second part of the request, I would not agree to any motion that would take away fees paid for a source test that was found to have failed, regardless of whether there's a future passing test or not. So as far as the second part of the request, I would also not agree with that. Any other thoughts? Mr.
Yes.
Camarena?
With, I guess we have to decide what is equity, or what is equitable, the definition. If we can compare it to the emissions, the excess emissions that we're charging for, 0.002 0.002 of a pound per day, 9 miles offshore, maximum 8 1/1000ths of a pound per day on a really heavy day. You're not going to measure that even short distance from the platform, let alone onshore.
I agree with that. However, I do know there must be a reason why there is a minimum daily fee amount, and that is adopted with the thought that there will often be cases where the amount of daily emissions are low enough that it would be a negligible amount. But the rule was adopted this way, I would assume, to ensure that there is compliance, and if there is no compliance, that there would be a minimum amount. So I'm not sure. I mean, it's true. Well, how do you see inequitability, but I don't know where I would draw that line or where I would draw that sliding scale. So I'm not sure that inequitability, I don't know, I don't think that changes my mind. I don't know about other members.
Just one other point. In most cases, the excess emission fees are not a driving force toward compliance. They're essentially a revenue item.
Any other thoughts? Anyone want to offer a motion on fees? If not, I can and see if it,
May I comment on the fee?
you may comment, yes.
I keep repeating this. When the district was created, it was decided at that point in time it would be funded by fee for service. In order to make sure that happened, there was a constitutional amendment approved by the voters of the state of California that says that property owners could not be assessed for a fee to support the district. Fee for service means just that. The lawyers are here, the staff are here, we're all here. And the budget's got to be adopted by this district, by the board. And if you keep not complying with the laws that exist, you may find yourself out of business. So I'm saying to you, it's fee for service. A lot of work's been done. You're here, you're getting paid. They got to be compensated.
I definitely agree with that. However, we do have to keep in mind that Rule 303M does give discretionary powers. So as Mr. Camarena stated, it does depend upon how each of the board members defines what is inequitable. And if we find in our own decision-making that it is inequitable in this situation, then we do have the power to waive or reduce the fees. But with that, I'm seeing that no one's offering a motion. I'm going to offer a motion and see if it passes or fails, and then we can move from there. But in the matter of Beta Offshore, case number 5855-6, I move that we deny the request to reduce and or eliminate part of the fees, emission fees, for failure to make the findings in 303M. Is there a second?
I can vote on that, right?
No, I would ask that you not vote on it
Reducing the fees?
because you were not,
I'm not voting on the issue, I'm voting on the fee.
but it was part of, all of the testimony given went into the decision-making on it. But as far as your thoughts on fees, I think that was highly appropriate. Is there a second, Ms. Byrd?
A second.
Mr. Camarena, oh, is there, a discussion on the motion?
Would you repeat the motion, please?
Yes. There were two requests made. So the motion would be to deny the request to reduce the fees beyond the minimum fees and to deny the request to eliminate fees should a passing test be, should the Tuesday's test found to be a passing test, if that's clearer.
It is, the senator has a point, and that is regarding the fees for service. With respect to service in this instance, I think the service or the filing fee for the petition addresses that. The other thing I want to point out is, and it's going to, my vote is not going to reflect what I'm going to say, that the cost of operating this hearing board is not covered by the emission fees, nor by the filing fees. It's way out of whack. This board conducts a lot of other matters, orders for abatement for which there are no fees, and the net result is that the revenue that the district gets does not come close to covering the cost of the hearing board operations. Never will.
Any other discussion on the motion? Mr. Camarena, how do you vote?
No.
Dr. Lerner, how do you vote?
No.
No. Okay. Well,
I vote, now you can count on my vote.
we have a tie vote. So the motion did not pass, did not carry.
No action,
There is no action on this.
same thing. Request dies.
What I can suggest, there is no action. So what I can suggest to the parties is if you want to renew your motion at another time, perhaps, if you need to come before this board for a regular variance with 5 members of the board, you may do so. But at this point, there is no action to be taken.
I suppose addressing the issue again on the merits is not welcomed.
I think we would have to repeat the entire hearing.
Well, I don't think any of us want to do that, but they operated only 1/24 of a day.
If you want to allow, if the parties agree to allow Senator Holden to take part in the voting, we can do that. But the parties would have to agree.
Do I have to?
I think we know the outcome of that.
Got a bit.
I think that, you know.
No disrespect intended, Senator Holden. But my client has been writing me little notes about the fact of the extremely low excess emissions, the fact that the crane is operated only roughly 1/24 of a day. And as the district was gracious to acknowledge, there was a dispute over whether there was in fact, a good faith dispute over whether there was in fact a failure.
Point of order, Mr. Chair, Madam Chair.
Yes,
The
Senator.
discussion is taking place, the vote is taking place, the issue is closed.
Why don't we take I want to check the rules to make sure that I am concluding this hearing properly. So we're going to take our 15-minute break now, and I'm going to come back on the record in 15 minutes and make a final decision as to the disposition of this motion.
Thank you.
I'm sorry.
And the discussion about the profitability was kind of vague for me. Do you, if you can, when you come back, if you had something that was better, you know what I'm saying? Because you said it was about the same. It's about, it's like, I'm trying to find whatever you're saying, but I just
We would have to reopen and re-argue the case at that point.
For that one point?
Well, let's come back in 15
Okay.
minutes, and we'll have that decision.
11:05?
So we'll be back at 11:05.
Thank you.
Do you,
We are back on the record. So in our break, I did take a time to consult with our rules and did confirm that, in fact, there is no rule that specifically addresses a split decision, being as we do have an odd number of members of this board. However, the effective date of decision is when 3 or more concur on a vote. So there has been no decision. So at this point, we can reopen for more information if hearing boards would like. Another motion can be presented by another board member, or we can proceed a different way. But let me first ask if any member of the board wishes to reopen for some more information. Ms. Byrd.
I would like the information that I requested before we went on break, if that's possible.
That's right, and now I can confirm that that is appropriate. We do not have to go to a rehearing because there is no decision. So, Mr. Tether, if you can present a witness for that.
Yes, thank you. Ms. Lang, can you respond to Ms. Byrd's question regarding the profitability of the platform?
I'll try. I actually don't work on the financial side of the business, so I can't really speak to what the costs are. I know they're significant to operate the platform, and these fees are unexpected. And if we were to pay the $186.03 just for the period of the short variance, would be more than $16,000. And if that precedence is carried over into the regular variance, it would be more than $50,000. And that's a significant hit to my budget, completely unexpected, as you can imagine. And we operate this crane on average 1 hour a day, and the $186 is like for a day of operating, but we don't operate for a full day. We operate for a very short portion of the day, which is why I believe the 25% would be more fair.
Thank you.
Anyone else have any more questions for Ms. Lang while she is testifying? Seeing none.
Thank you.
Ms. Byrd, did you?
I'd like to offer a motion and maybe a compromise on the board so we can get a decision in the motion, because I can compromise. And we have done this in the past. The petitioner is requesting 25%. I would like to offer a compromise of 50% of the 181 per day, with the idea that inequitable can be attached to the what the petitioner just mentioned, the fact that this is only operated minimal time for the day, and that would mean it would be in the and this number of 186 keeps being mentioned, and my book maybe might not be updated, but I've got 181.49. I don't know what's in anyone else's book in the Rule 303. So I'd like to offer that as a motion. I move that we allow petitioner 50%, reduce the fees by 50% of the whatever it is, if it's 186 or 181.49, as opposed to requiring the entire amount for their excess emission fees.
Is there a second?
I'll second.
Okay. I'm asked for a discussion on the motion, and I'm just going to say for the record that some of the information that was given upon reopening the hearing does put that, as Mr. Camarena had suggested, looking at inequitable a little bit more in perspective as being a bit lopsided when you add up the amount of fees over the course of the short and/or if where they need to come back for a regular, but that's not before us today. But and given the 1 hour duration of time that it's used on average. Okay, so with that, Dr. Lerner, how do you vote?
In favor. In favor.
I'm going to keep my vote as it was before, but it now passes 3-0. And we have a disposition. I'm sorry, 3-1. Thank you for that helpful math.
Given that the short variance expires, I believe, the 17th of October, I actually have this little wheel, paper wheel, and I can spin it around. It's very primitive, but it allows me to count days. But would it be appropriate to calendar the regular variance? And we would hope to be able to request the removal or withdrawal of that petition.
I think it's up to, at this point, I think it's up to the petitioner. When we started this hearing, I was seeing it a different way. And I think it's up to you, Mr. Tether, if you wish to try to calendar that regular variance now or to wait and see. But your time is short to wait and see if you don't want any
Yes,
lapse in coverage.
and I'm on vacation some, so
Okay. So you're looking for,
a date, please.
and what would be a date by which we could calendar, given the notice provisions and requirements? 30? About 45 days from today? Okay, so that would mean, that means I have to use my math again. So no sooner than the 25th of September.
6 weeks and 3 days. If you have a calendar that goes by the weeks.
But you know, this goes through, why don't we look, then let's look past the 25th of September, which happens to be a Monday. Let's look in the early October. The 17th is when it ends. We are open on the 10th of October. Would that work for the parties?
Yes, that would be fine. Thank you.
Okay, then we will schedule the regular variance for the 10th of October. Okay, so since we just took our break, I think we'll call the second case. Thank you very much.
Thank you very much, and
Sorry?
Before we close out, point of information in the statement I need to make to the petitioner, that the last time they had the issue before us in January, December, they asked that it be put in the consent calendar. And I moved that it take off the consent calendar, and I had the authority to do that. That is, in terms of approving the regular variance. They went to the, am I right?
Yes,
Yeah,
we've
so I don't
prepared-
want to see that happen again. If they're going to come back for a hearing on a regular variance, then that's going to be the date set, fine.
Okay. May I suggest, it is up to the parties to request the relief they want. If they request consent, then any member of the board has the opportunity and right to take it back off.
And when I tried to do that, I got a pushback from the chairman and Mr. Lang.
I'm gonna stop that conversation right now, since
Just let you know what
none of that is before the board right now. It's up to the petitioner to request the relief that the petitioner seeks, and it's up to the board to make the decision.
thank you all.
Thank you.
Before we, what date did you set?
I set it for October 10th.
That's 45 days?
No, it's past 45 days, but before the short ends.
It's October 17th. Did you say the 45 days will be when?
Was that? I didn't know.
How you been?
So it's 45
mid-September,
days.
so that way
Okay.
we're
Englewood.
45 days from
Yeah, I was told
today.
you were here. I missed your first case.
You didn't miss much. I'll be back next week.
Okay, very good.
going to call Bowerman Power, case number 6088-1 for a short variance. Who is representing Bowerman today?
Robert Hines for the petitioner. And we'll need just a moment to get set up, if that's okay.
You know what, let's go off the record.
Oh, I'm sorry, thank you. Oops.
Thank you. Welcome back. Same thing.
We're back on the record. Who is representing Bowerman Power today?
Robert Hines for the petitioner.
Thank you. And for the district?
Mary Reichert on behalf of the district.
Thank you. And let's begin by anyone who's going to be testifying today, please stand up to be sworn in. Please raise your right hand. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God? Thank you. Before we get started, I want to mark, and I'm not sure if all board members have this, but if you don't, it would be important. There was an email from Mr. Hines dated, well, it's a chain, but the top one is July 27, 2017, to the clerk of the board, and it is essentially, or effectively, an amendment to the petition. So I want to make sure either that all board members have it. Okay, but we'll make sure, I'm sure we're not going to finish before lunch break, so make sure we get that. But this is effectively amending the petition to request short variance relief as opposed to regular variance relief. And I'm going to mark this as exhibit number 2. And with that, Mr. Hines, you may make your opening statement.
Thank you. It's nice to be back before the hearing board, Madam Chair, members of the hearing board. My name's Robert Hines, and I'm with the law firm of Farrell, LeBron, and Martel in San Francisco, and I'm appearing here this morning on behalf of Bowerman Power, LFG, LLC. Bowerman Power is a subsidiary of Montauk Energy. And as the hearing board knows from our appearance before you about 2 weeks ago, it was July 26, where we appeared for an interim variance. Bowerman operates a landfill gas to energy facility at the FR Bowerman landfill, which is located in Irvine, Orange County. At our last hearing, where Bowerman Power sought an interim variance, the hearing board declined to grant that variance, finding among other things that petitioner did not establish diligence. And so, in turn, we were not able to demonstrate good cause. We did not proceed to the merits on July 26 as a result, and we're here before you now as a result. So following the hearing, and this relates to Chair Prusak's marking as an exhibit the referenced email, in coordination with District Council and in coordination with the Clerk of the Board, we set a short variance hearing for today. The August 24th regular variance hearing actually still remains on calendar. I looked outside. But we're here before you on a short variance for reasons that I will explain. In the context of that coordination and as set forth in the email, Bowerman, District Council, and the clerk concurred that the approach that I just referred to, where rather than wait until August 24th to come before you on the regular variance, which had been noticed for August 24th, we identified a preferred path forward, which was to set this short variance hearing for today. The short variance hearing being set for today, again, this is in consultation with District Council, is allowed, we believe, by Health and Safety Code sections 40825 and 40826, and it's consistent with those Health and Safety Code provisions. We obviously recognize the distinctions in notice between a short variance and a regular variance, and we appreciate those distinctions. Having said that, we think that the hearing board can certainly appreciate Bowerman's desire to get back before you sooner rather than wait until August 24th to present the merits of our variance request. With respect to today's proceeding, and as you heard on July 26, Bowerman is among the first landfill gas to energy projects that's permitted under Rule 110.2. And specifically, Bowerman was permitted to operate the internal combustion engines with substantially reduced NOx limits under that rule. And we believe that, the problems notwithstanding, that we are only we are to date the only permitted facility to be up and running in this context. We will present testimony this morning to the hearing board so that the hearing board may make the 6 findings necessary under the Health and Safety Code to grant Bowerman the short variance relief that we're requesting. We will also present testimony regarding the initial stages of Bowerman's assessment work, which I talked to you about when we were before you on July 26, and which Ms. Frank testified to as well. So we'll describe some of the early observations from that effort and be in a position to report on those. We will also describe through testimony, excuse me, our work with district staff to agree on proposed variance conditions, which we have done so, and they've been distributed to the hearing board. In point of fact, they're not really different substantively. There were some changes, small edits made between what we agreed to in prior to the interim variance and today. Basically, some dates were changed and things were brought current. And I can also say that there's also been a great deal of coordination between district staff and my client, and with respect to operation and with respect to assessment. And so we've been working towards that end very diligently. So by way of my opening, I'll just thank you in advance for your consideration of Bowerman's variance request. We're confident that if the variance is granted, that Bowerman will be able, with its experts and consultant colleagues, to determine the cause of the facility's periodic exceedance of the NOx limits in the permit and to develop and implement an appropriate path forward.
Thank you. Before I ask Ms. Reichert for your opening, first of all, I just wanted to mark the proposed variance conditions as exhibit number 3, but also to ask if you would like to incorporate Mr. Hines and Ms. Reichert, the I think quite substantial testimony from the interim variance hearing.
I think it makes sense to do so. Having said that, as we noted, we didn't really reach the merits, so we'll be going through probably more summarily than we did last time some of the same information, but it does make sense to incorporate it from our perspective if district council's in agreement.
I have no objection.
Okay, so then we will incorporate the previous testimony into the record. Ms. Reichert, your opening.
Thank you. The district acknowledges that this is a somewhat unique procedural posture in this case, but we have discussed the issue with Petitioner and examined the code, and the district does not believe that anything in the code prohibits the granting of a short variance, even anticipating the setting of a regular variance subsequent to that, as actually previously happened earlier today. Subject to the testimony presented here today and compliance with the proposed conditions, the district is not opposed to a granting of this variance.
Thank you. Mr. Hines, you may present your first witness.
Our first witness is Ms. Sharon Frank. Ms. Frank, would you state and spell your name for the record, please?
Yes.
Yes.
The presentation by Ms. Frank will be lengthy as was 2 weeks ago or so. And if you have lunch, so it will not be disjointed. Start at 9 and you come back and you take over. I'd rather hear from the beginning to the end and then we vote.
Well, normally we take a break sometimes in the middle of a case, but would you be able to, I was thinking, well, let me ask my fellow board members, would you, since we took a late break, I was thinking of a 12 o'clock lunch. Would that, is anyone hungry, too hungry to wait until?
All I want to say is that
noon?
last time she spoke for about an hour or so.
Well, let me
When the
ask,
presentation.
let me ask, how much is your affirmative presentation going to take?
I think it'll take a little bit more than a half hour, but I would ask for the hearing board's indulgence because I think we can move through the issues relatively quickly. And if we can present the case in its entirety through the slide deck before we break for lunch, that might be preferable.
Okay, and if we can, given that we incorporated the testimony from the last hearing, if we can move it as quickly as possible, I think that would be appreciated by the board.
We'd be pleased to do that.
Okay, and let's mark that as exhibit, let's mark the presentation as exhibit number 4.
And just for the record, hearing board members, the
I'm sorry.
PowerPoint presentation that we copied and is marked as exhibit it's updated and slightly different from the prior one.
Okay, thank you. So this will be exhibit number 4. That's a good question. I marked the proposed variance conditions as exhibit number 3, but those are the districts.
Technically, they're the districts, but we've both agreed to them, so I don't think it matters if you want to
Okay.
have them as petitioners.
So for E, thank you for that, Ms. Byrd. So for ease, let's leave it marked as is.
Ms. Frank, welcome back again, and would you please state and spell your name for the record?
Yes, Sharon Frank, first name Sharon, S-H-A-R-O-N, last name Frank, F-R-A-N-K.
And did you take the oath?
Yes, I did.
And can you just provide your position with Montauk Energy, please?
Sure, I'm the manager of environmental compliance for Montauk Energy, which includes Bowerman Power, which is one of our subsidiary companies. I manage the environmental compliance for the company. That includes source testing and environmental training for all of our operations personnel.
And you've worked on a slide presentation for today's hearing that will assist in your testimony, is that correct?
Yes.
Okay. And so we'll start with facility background, and as indicated by the hearing board, we were before the hearing board in late July, so much of the information by way of background has been provided to the hearing board, so it may be possible to move through some of these earlier slides a little bit more quickly. Do you agree?
Yes.
Okay, thank you. So in terms of the facility background, if you could just highlight some of the key aspects of the facility and including its relationship to the parent company, Montauk Energy.
Well, again, Bowerman Power is a subsidiary of Montauk Energy, and again, just in general, the facility collects, treats, and combusts landfill gas to produce renewable energy, which we sell to the city of Anaheim.
And how many internal combustion engines are permitted and operate at the facility?
There's 7 internal combustion engines, each with 3.3 megawatts capacity.
And are you currently operating?
Yes.
And what's the amount of energy that goes to the grid currently?
Currently near capacity, 19.3 megawatts.
Okay,
go to the
thank you.
grid.
And we'll try not to talk too fast, but we'll try to move through this quickly. There's always that tendency. So the next slide details some of the permitting aspect of the facility. If you would not mind reminding us in the hearing board of some of the aspects of the permitting background, please.
Certainly. Again, as it was presented initially, Bowerman Power is actually the first landfill gas to energy facility permitted under the district's Rule 1110.2 with the emission limits of 11 ppm of NOx and 250 ppm of CO. In order to meet those limits on landfill gas, we had to install pretreatment system, SCR, oxidation catalyst, and we opted for an ASIM system because we had to continuously monitor those emissions.
And when we were before the hearing board for the interim variance hearing, you talked a little bit about the assessment process that the consultant FERCO is going through. Which aspect of the operation is that assessment looking at?
Primarily, the assessment is on the SCR, which is where the problem is right now, controlling the NOx from the source, but also it will touch on the pretreatment and as well as how it's monitored through the ASIMs.
Thank you. So we'll move to the fourth slide. Ms. Frank, can you please describe how the landfill gas is controlled at the facility?
Sure. The flares at the Bowerman landfill, it's either controlled by the flares or the landfill gas to energy facility, and there is a point where the landfill gas comes in through a common header. The flares, there are 5 flares, and the primary control device is the engines, and as we stated, that consists of 7 engines, but the landfill gas, if the engines are not operating, can go to the flares. And the fact is that if the engines are not operating for some reason, the gas has to go somewhere, and it will be controlled by the flares at that point.
And the Title V permit covers what at present?
The Title V, Bowerman's Title V facility covers the engines and the treatment system, the pretreatment, the SCR, and the urea storage tank we have.
Okay, and you're also permitted for a landfill gas flare, but that's not built yet, is that correct?
It wasn't, it will not be built
Will not
because,
be, okay.
correct, because we modified the county's flares.
This next slide shows the Bowerman facility process flow, and this is tied in with the next slide as well, I believe. If you could you just very quickly walk us through the process as it relates to as it relates to the requested relief today?
Okay, sure. The part that comes through the engine facility consists of a pretreatment, which includes H2S removal. We chill the gas, we compress it, and we send it through a siloxane removal system. Then that clean gas comes into the engines and where it is combusted. The siloxane removal system has to be regenerated periodically, and that is regenerated with treated gas as well as air. The off gas from that regeneration process goes to flares 3 and 4, which have been modified, which those flares are under Orange County's permits.
And the flares on this particular process chart that you're referring to are depicted by those red triangles in the right-hand corner, is that right?
Correct.
And then in terms of the exhaust treatment system on the next slide, how does that relate to the operation of the system?
Well, this diagram is key in that part of the problems that have been observed by our SCR expert have to do with the configuration of the SCR housing, the system itself. I want to point out here from this diagram is that we have a urea injection system that treats the NOx coming from the engines. It goes into the SCR housing, and then the sample point is after the SCR bricks. The key in this picture is that the oxidation catalyst, where the CO is controlled, is after the SCR bricks. Then the treated gas goes out the stack after it goes through a silencer.
And when you refer to the SCR housing and the bricks are a component of the SCR system. Is that accurate?
Correct. That's how what they're made of. They're bricks.
And those are changed out periodically. Is that right?
Well, we had initially projected when we obtained the design of this system that the bricks would not have to be changed out for approximately once every 3 years. But what we have come to find out, and which we will present a little bit later here, is that they are degrading rapidly. So we have changed them out frequently. After startup of the system, we had to.
Thank you. Is there anything else on this slide that you wanted to point out that might be germane to the hearing board's consideration today?
Not at this time, no.
Senator? I don't think your microphone is on, Senator.
What about the sampling point?
The sampling point?
Yeah,
Okay, let's see.
on that slide,
On this slide right here?
when you just discussed, yes.
Okay, all right, sure. The Stoiler sampling point is between the SCR bricks and the oxidation catalyst. Initially, when we obtained the design from the Stoiler manufacturer, that sampling point was after the oxidation catalyst, which led to a problem with the control of how that SCR system is to work. Because we're going to discuss here in a little while, what happens is that you have ammonia slip through that SCR brick layer, and it is further oxidized when it goes through the oxidation catalyst, which creates more NOx. So it was giving an erroneous reading, a feedback for sampling and controlling the SCR.
When you find that the feedback is,
Clarification of any slide, but beyond that, let's hold our questions. Go ahead, I'm sorry.
That's okay, thank you. I appreciate the clarity. And then in terms of the compliance point, just staying on this slide so that that's clear, what is the sampling point for compliance that is utilized here?
Sure, it's after the exhaust silencer. It's called, labeled the RADA sampling point there. That's where we take our source test readings.
And just for the record, RADA stands for?
Relative Accuracy Test Audit.
Thank you. And then the next slide talks about or details some of the facility startup. When did the facility start operations?
It started up in February of 2016, and we had some issues throughout the year. And initially, we attempted our ASIMS RADA, but we couldn't. It had to do with the location of that sample point after the oxidation catalyst. And it basically is because we have ASIMS, which is a predictive emissions modeling system. And we had to reconfigure the SCR so that it would operate as a typical system so that it could be modeled under the ASIMS protocol.
And in the context of that work and some of the discoveries and startup issues that you were having, did you meet with South Coast staff to discuss those issues?
We did. We met with them in August of 2016 and discussed our issues with regards to trying to conduct the RADA testing, and yeah, we met with them then.
Thank you. And there's been a variety of discussions over time. How would you characterize your relationship and the degree to which you communicate with district staff?
We've tried to be as transparent as possible in the problems we have encountered with this new technology and its implementation and trying to get this facility started up. So.
And then what occurred after August 2016 in the context of startup?
In a path to reschedule the RADA, we tried to change the configuration of the SCR sampling, which was shown on that figure. We modified the controls on the SCR. We changed all the media. We changed out the pre- and post-treatment medias and really tried to tune the SCR, and then we rescheduled the RADA to March of this year.
And just by way of clarity, when you talk about ASIMS being a predictive model, what exactly does that mean? Do you have to work with another consultant in the context of that modeling effort?
Yes, Rockwell International is the company that designs the ASIMS, and it's basically a computer software program that they install that uses different operating parameters to predict emissions of NOx. So they identified different parameters. They went through a set of what's called step testing and evaluated the process for all different type of loads, and then came up with a model.
And that ASIMS that's a calibration process, is that correct?
Well, currently, that's what we are experiencing at this time, is that what we are finding out with this ASIMS, which is also really a new type of technology, is that it has to be calibrated frequently with this system, yes.
And then this slide also indicates that you changed all the media pre- and post-treatment. That would include the bricks, is that right?
Correct. We changed the bricks in the pre-treatment.
Okay, Ms. Frank, this next slide is a project timeline. And I think this picks up in the 2017 timeframe. And if you could just quickly maybe highlight some key aspects in terms of this particular timeline over the course of 2017 for us, that would be appreciated.
Okay. Again, we rescheduled the RADA for early March, and after the RADA was completed, we went through a process where we had to start up our reporting system, and that started up the beginning of April. Once we found out that the reporting system, through that reporting system, we were seeing random exceedances, periodic exceedances of the NOx emissions, we contacted the SCAQMD, and we sat down and we had a call with them in mid-May. At that time, we identified some corrective actions that we had been working on in our operations and engineering group to help us come into compliance that we thought we would prior to the source testing that was scheduled for June, that did occur at the end of June. So we discussed those corrective actions, and we did install those corrective actions, which had to do with, we changed the control system on the pretreatment system, and we installed a pressure control valve on the pretreatment process. So we did that, and then we started the compliance testing at that point, as I think we had discussed on our previous visit here before you. We contacted the the South Coast and let them know that we were not expecting to be in compliance with that source test, which in fact we were, preliminary results showed that we were not. And we received a notice to comply. We responded to that, and
If I could just stop you for a second. With respect to that notice to comply, that was an informational-based notice to comply, is that right? Where information was requested from Bowerman?
that's correct.
Okay, thank you. You may continue.
Sure, we provided that information, and it appeared to be satisfactory to the district, and then we submitted our petition for a variance in July 12th. It was received, and again had the interim variance hearing July 26th, and we started with the FERCO assessment also that same day, July 26th, and of course today as we have discussed the short variance.
And the SCR expert was engaged towards the end of June, is that correct?
Right after the STAC test, yes, we engaged him and got him involved.
Okay. And then they've been on site basically since July 26th, is that correct?
That's correct.
So when did you first become aware, or not you, but when did the facility first become aware that compliance was not achievable?
Okay, as I mentioned, we started to see periodic emissions, excess emissions, when we implemented the reporting system in April of 2017. They were periodic and they were self-correcting. When we really realized that we could not come back into compliance was prior to the emission source testing, June 19th, and that had to do with the bias that we realized had to be installed on the ASIMs because they were reporting slightly different numbers that were not accurate. We thought they were reporting lower numbers.
And did you contact the South Coast District staff at that time?
We did prior to testing and discussed our regulatory options with regards to testing.
Okay, and some of the preliminary results from the compliance testing have been passed along to district staff, is that right?
Yes.
So in terms of some of the SCR control issues that you've talked about, can you describe the unanticipated nature of those issues for us?
Certainly. Primarily, our design company, our design engineer, Stoiler, had very little experience with designing and implementing an SCR system for landfill gas. A lot of the problems that we have anticipated had to do with the change of the methane quality as a part of the pretreatment system. And that was something that we really did not anticipate, that the methane swings would cause the NOx coming from the engines to change so rapidly because the engines were overcompensating. In addition, like I said, I think it had to do with the design engineer not anticipating the level of, I guess, variability in landfill gas emissions, as well as how to control it accurately.
And during that time, did Bowerman make modifications to the existing SCR to try to address some of these issues, including the methane spikes?
Yeah, we did. This was what we did in May. We installed a modification to the program to try to level out those swings.
And again, this is it's not a relatively new technology per se, because landfill gas to energy projects have existed for a long time, but in the context of meeting the stricter limits associated with NOx, this is really a first of its kind project. Is that accurate?
Yes, this really is the first in the South Coast District. I had discussed this with district engineering staff and confirmed that there are a couple of other facilities that have been permitted off of landfill gas using SIMS as well as SCR control, but those facilities have not started reporting. They have not completed their compliance testing, and they have not supplied the data that we have supplied in trying to come into compliance with that 15-minute average. that is required by 1110.2. So we are the first facility that's trying to meet that 15-minute average.
Okay, thank you for that. Next, we just wanted to touch on, obviously, curtailment and ceasing operation is a consideration that needs to be taken into account. What are the ramifications here associated with not operating the engines? And actually, let me ask a prefatory question. In the context of the FERCO assessment, is it necessary for the assessment to be optimal for the engines to run at full loads?
Well, it is because we have seen that the main problems with the SCR occurs at maximum load. And we need to understand how to correct those problems, so we need to run at full load. As I think I had mentioned before, it would be like idling your car and trying to fix the engine. We need to run it at full load to understand how to correct those problems within the SCR system. So
with that context, then what would be the ramifications of not operating?
well, we would default on our PPA that we have with the city of Anaheim, which is a 20-year power purchase agreement, which would be a loss of $14 million per year and $6.6 million in penalties for breaching that contract. We would default on our secured credit to build this facility, which is $38 million. We would lay off the 5 employees that are at the facility, and of course, the loss of energy to over 11,000 homes of renewable energy. And I'm sorry.
Just wanted to pause for a second. And it's not just the city and Bowerman Power and its employees who would be impacted. There's other implications as well with respect to Orange County. Is that right?
That's right. Orange County, we provide O&M services for them to operate their well field, so they would have to retain those services, as well as we pay a $1.5 million annual royalty payments to Orange County as part of our agreement with them.
So moving to the next slide, if the plant is shut down, would landfill gas continue to be generated and released to the atmosphere?
It would. That's the issue, is that under federal and state regulations, the landfill gas, the source is the landfill, and it would have to be controlled by either flares or a beneficial use, which is the engine facility.
And as I recall, we presented testimony. You testified to sort of the distinction, if you will, or what the difference would be between operating the engines and having the excess emissions of NOx as you've identified, or if the engines were shut down, the landfill gas simply being flared. Did you subsequently work with district staff, specifically Charlie Tupac, to more refine those calculations?
I did, yes.
And what was the result of that?
I shared our calculations with him, and we came to a conclusion that actually, if the engines were shut down, the flares would emit approximately 85% of the NOx that's being generated by the engines.
And I think you testified in the last hearing that there's SO2 as well that is emitted to the atmosphere through the landfill flares.
That's right. The H2S that comes in the landfill gas is controlled going to the engine facility, but it's not required to be controlled going to the flares.
So you've talked a little bit about how Bowerman needs to operate at full load to assess the SCR problems. In terms of the operational assessment, what's the manner in which Bowerman has determined it's best to proceed?
Well, the best thing for us to do to understand the problem is we have hired FERCO here to try to understand the nature of the SCR problems. Some of them we're going to talk about what his initial observations have been. But as I mentioned, we have to operate at full load during this assessment period to understand the nature of the problems and determine how we can really fix it.
And that's actually a good segue to talk first about the proposed variance conditions, and then I think we have a couple of slides that provide some detail in terms of what we'll call preliminary observations. So in terms of the variance conditions which the hearing board members have and which you've worked on with district staff, what are the general conditions that have been agreed to and that, in fact, in some respects, Bowerman has already met?
That's right. The general conditions involve the calibration of our ASIMs using the FERCO mobile laboratory to do that initially, and then on a monthly basis to bring in a certified SIMS trailer to calibrate our ASIMs in order to conduct the monitoring during the variance period. The other conditions are involved around finding out what the corrective actions are that would be recommended by FERCO, and to proceed with that at the implementation of those recommendations.
And there's a general condition as well that once compliance is achieved, you'll notify the clerk of that, is that right?
Correct.
And if the regular variance coverage is determined, or if the short 90-day variance period is determined to be insufficient, what does Bowerman plan to do at that point?
Well, we would come in to request a regular variance hearing before the board. We do feel that we would have some very good preliminary information within 45 days.
Okay, and let's move now to the actual observations that have been identified over the course of the last really several days, given that this work just started on July 26th. Can you talk to us about what some of those preliminary observations are? Let's start with the catalyst deactivation header there.
Sure. FERCO had suggested initially they removed all the catalysts out of one of the engines and took it to their laboratory and conducted studies on it. He found out that the catalyst is undergoing a rapid deactivation much quicker than would be anticipated for a natural gas facility, and that laboratory testing is ongoing.
With respect to the CO catalyst, what observations and what work is going on in that context?
Okay, again, as I mentioned, with Stoiler's design of their control system, they located the CO catalyst downstream of the SCR catalyst. That is a problem with regards to ammonia slip. That ammonia slip is being oxidized to NOx in the CO catalyst, which is on the back end of the system. That compromises the NOx compliance because it essentially increases NOx after the SCR catalyst, and it shortens the life of the catalyst.
When you refer to the ammonia slip, can you describe that maybe just kind of quickly in a couple of sentences in layman terms? What does that actually mean?
Sure. Urea is the reagent that is injected into the SCR bricks to reduce NOx. If there is an excess amount of urea injected, it will slip past the SCR catalyst housing and it'll exit as ammonia. So.
Okay, thank you for that. And then there's one other heading here, reagent stratification entering the catalyst. Can you describe the observation and what that's all about?
Right, FERCO did some testing with their probes and they found out that there is a stratification on the urea entering into the SCR, in that the urea is laying along certain edges and it's just not being uniformly dispersed throughout the catalyst, so that it is ineffective, and it complicates the control of the system to the point that we cannot obtain a representative sample. It increases the ammonia slip, and that also shortens the catalyst life.
And the shortened catalyst life, that's obviously not something that that's something that you want to avoid and something that the design tried to take into account. Is that right?
That's correct. If the static mixer were designed properly, it would disperse the urea evenly to keep the catalyst evenly, exposed. Some of it is being overexposed.
So I guess just to kind of on a 30,000-foot level, this is all taking place to meet those very low NOx levels. Is that correct?
Correct.
And when I say this, I'm talking about the operational efforts, the design, and the system issues that you faced.
That's correct.
And in terms of some additional observations by FERCO, what's been observed with respect to what's labeled here, the SCR controls?
Well, on the SCR controls themselves, we have a control that was set up by Stoiler called load table only to control, attempted to control NOx based on the load of the engines only, which is not effective in controlling the NOx. They have another control scenario, which is called load table plus analysis. It uses the Stoiler NOx outlet, but it does not measure the NOx coming from the engines, which is problematic in reducing the NOx to the appropriate level without causing ammonia slip. The Stoiler NOx measurement is not representative due to the stratification that we just discussed, and FERCO identified that the Stoiler NOx measurement does not account for the ammonia oxidation across the CO catalyst.
And as you mentioned, FERCO continues to engage in its assessment activities, is that right?
They are, yes.
And they're expected to continue for the foreseeable future?
Correct. One of the proposed conditions that we worked out with the district are that they would be there for a minimum of 30 days to obtain NOx emissions data, but they have some objectives based on these preliminary observations to continue for, I guess, another 3 weeks to collect data.
Thank you. So at this point, we just have a little bit more testimony in terms of sort of concluding with variance findings and trying to put this into context with respect to the 6 findings that are necessary for the hearing board to make under the Health and Safety Code. With respect to this first bullet item, that the petitioner for a variance is or will be in violation of any rule, regulation, or order of the district, is Bowerman currently in violation?
Yes, we're in violation of Rule 1110.2 and the current Title V operating permit.
Okay, and then the second finding that's necessary has to do with conditions beyond the reasonable control of the petitioner, and that requiring compliance would result in either an arbitrary or unreasonable taking or the practical closing or elimination of the lawful business. What would be the effect here of a full-blown shutdown?
Shutting down the plant would result in about $45 million loss one time, and then a loss of $14.2 million in revenue annually for a 20-year period, and then we would have to lay off those workers that are there.
And you've testified that information was set forth in more detail, I think, early in your testimony, correct?
Correct.
The third finding that's necessary has to do with that the closing or taking would be without a corresponding benefit in reducing air contaminants. And I think you testified to this in the context of the flaring that would take place regardless of whether the engines were operated. Can you speak to that issue briefly, please?
Sure, yes. We have agreed with the district that the flaring would cause similar NOx emissions and potentially increase SO2 emissions.
And that was at about an 85% rate with respect to NOx emissions, correct?
Correct.
And then with respect to number 4, that that Bowerman has given consideration to curtailing operations of the source in lieu of obtaining a variance. Has Bowerman in fact considered curtailment?
Yes, we did, but that would not solve the problem. We wouldn't be able to figure out what is wrong with this $50 million facility that we built and trying to operate as a beneficial use of landfill gas, and we would not be able to demonstrate the application of new technology to meet the new emission limits that the district has put forth, with us being one of the first sources to do so. And in addition, the landfill gas would then still just have to be flared to no beneficial use.
Okay, thank you. So moving through the variance findings, the 5th one is about reducing emissions. I should move to that slide. Will Bowerman do anything in particular to attempt to mitigate, reduce excess emissions to the extent feasible?
Yes, we've already reconfigured the engines as we have presented before on the bus such that the highest emitting engines as identified during the source testing 1 and 3 are currently operating at lower loads, while the other engines are operating at the higher loads to meet our load demand.
When you mentioned the bus, what is that?
That is the Southern Cal Edison's bus that distributes the electricity into their transmission distribution system.
Thank you. And then number 6, will Bowerman Power monitor or otherwise implement the agreed-upon variance conditions to ensure consistency and meeting this particular finding?
Yes, we will monitor the emissions. Our ASIMs will be calibrated monthly as we have set forth as they are identified in the proposed variance conditions, and we will continue to work with the district staff to identify and implement a permitted path forward.
Thank you. That concludes Ms. Frank's testimony.
Thank you. We will take our break in a moment. I just wanted to, since Exhibit 2 was marked, that is the email correspondence and the amended, which essentially stands as the amended petition, I just wanted to correct one statement that was on there, just for the record. On the second page, it states, I'll just quote it, "You indicated you would preview this approach with Chair Prusak. If there are any concerns on your or the chair's part with this approach, then we should keep the regular variance on calendar for August 24th, and we will see you then." And just for the record, I wanted to state that that was passed by me by the clerk, and the response to that was that would be improper to have a one-member hearing. And so that actually preview was not actually did not take place.
And the clerk's response made that very clear, and we apologize for creating any confusion in that regard.
Thank you. I just wanted to make sure that was clear.
Appreciate
since I was
that.
going
Thank
to be
you.
reviewing that. Let's take a break here for lunch, and we will reconvene at 1 o'clock. We are off the record.
50 minutes.
We are back on the record. Unfortunately, we have lost, we're back on the record. Unfortunately, we've lost one of our board members who had something that he could not get out of. So we are down to 4. Hopefully, unlike in the last case, we will have not a stalemate, but let's proceed. Okay, Ms. Reichart, we were up to you on questions for the witness.
Thank you. I just had a couple of clarification questions. You had mentioned that some of the troubles that you were having is, because the system is unique in trying to attain these lower limits. Can you describe what's different about the system from other similar type facilities?
Well, actually, there are no other similar type facilities in period the difference is trying to meet this 11 ppm NOx limit and the CO 250 ppm limit on a 15-minute average. There are no other facilities in the country with those limits. That's what's unique.
Okay, so you're making adjustments to the system. So what different adjustments are you making to attempt to achieve those? Like what's different about the system that you're hoping will cause you to achieve that limit as opposed to other systems that aren't seeking to achieve that
Okay,
limit?
other systems, they would have higher limits. That's one of the, just what I guess my point. Some of the things that FERCO has, their objectives are to continue testing on the other engines, to remove the catalyst out of another engine to test for its degradation, to check stratification on a couple of the other engines. Again, that's part of the conditions, is just to really identify what the main problem, it's a number of problems. And perhaps even Larry Muzio, who is FERCO, could even elaborate if you wanted more detail on the, kind of the suggested corrective actions. At this point, they're very preliminary.
Okay, maybe he'd be the better witness for that. I also had a question about, you had mentioned on the slide that some of the problems were causing a shortened catalyst life. And can you describe why that's a problem? Why just placing it more often is not really feasible?
Well, it's a financial burden, and then also it's a compliance issue. I mean, you want to be able to comply for a longer period, and if it degrades too quickly, you are rapidly falling out of compliance over a period of time.
And how much does the catalyst cost to replace?
Oh, that's a good question. I am not certain. I want to say each engine maybe on the order of $100,000.
If you're not the right person, we can ask.
Yeah.
Okay, I just was curious on what that was. That's all I had. Thank you.
Thank you. I had a few questions. My first question is, so we know that the interim variance was not granted. Has Bowerman Power been operating the equipment since that time?
Yes, we have.
Okay, so that was the choice. So you have not been flaring, you have been operating the subject equipment?
Yes.
Okay. The other question I have is if you can explain a little more in detail, it doesn't have to be a long explanation, but in the regular variance petition, which has now been amended simply to ask for short variance relief, there was a timetable that was set out with a request for approximately a year of a regular variance. Can you explain how, if so, how that timetable has changed now that you're requesting short variance relief?
Well, I think as Buzz had mentioned at the beginning, is that we intend to try to identify the issues within the 90-day period, which would fall under the proposed variance conditions. If at the point that we find we obtain recommendations from FERCO, which we expect to obtain within that short variance period, we would come in to request a regular variance for implementation of those corrective actions.
So the change is simply to take out the implementation phase of any suggested changes, and really you're requesting a short variance to go for 90 days, and in that 90-day period, the timeline would allow for final suggestions by FERCO?
Correct. That's what condition, I want to say, condition 7, it allows for the expediting of procurement and delivery, installation, and startup of all parts for the implementation of the engineering solution.
The variance for which you seek relief is from emission limits, isn't that correct?
Correct.
And that relief you're going to need far longer than 90 days, is that correct?
Well, we believe that initially we could meet the conditions proposed within the 90-day period, but again, because it will be on such a large scale that we will have to modify our system to meet the emission limitations, it is very likely that we'll have to come in and request a regular variance.
Is there any scenario under which you believe that it is likely that both the FERCO review and recommendations and implementation of those recommendations and compliance would occur within 90 days?
Not at this time. I believe, based on discussions that we had with FERCO on delivery of some of the materials that are suggested for the assessment part of this, would take time to purchase.
Do you, at this point, believe that the time frame overall, including the implementation, is closer to what was laid out in the regular variance petition?
Yes.
Was that yes?
Yes, we do.
Yes.
Yeah.
Okay. Any other questions, board members? Would you like to take a moment, or no other questions? Okay, seeing. Yes.
Without notice.
There is notice. There's a different notice that is required for short variance than for regular variance, but there has
About 10
been
days, right?
10 days posted.
Right. Well, when you ask for interim or short, you also suggested that you ask for regular, which they're perhaps are doing. And back in, they knew they had a problem when they got the notice of violation. June 27th. So therefore, they knew they had to do some things.
Are you asking me questions, or do you have questions for the witness?
And June 27th, did they give you a clue that you might need to apply for interim or short variance at that time?
That was when we prepared the variance and applied for it, yes. Was June, after the notice to comply was issued to us.
Under the terms and condition of an interim or short variance, the time requirement to post notice.
Do you understand the question?
I'm sorry, I don't know.
Yeah, you had to post notice for either the interim or the short variance at that time.
Oh, correct, correct.
And you were given notice that you had to, something had to be done.
Yes, sir, and we took the route of going with the interim request, not understanding the administrative issues regarding notice, as well as a regular variance at the same time. That's what we initially requested.
But you were here about 2 weeks ago, right?
Yes,
You could have given notice for a short variance at that time.
we did. That's what we did.
Okay. All right, next question. The reason why I wanted to raise some questions during the presentation, because you get lost otherwise. So I'm going to start out by going back and ask a simple question. Virgo observation, for an example. Look at that page. you explaining where the catalyst is located downstream of the SCR catalyst. Is that clearly explained on the facility process flow, or is it explained on the exhaust treatment flow?
It is, yes.
Which one?
It's on the exhaust system flow diagram. Can you go back
Let's
to
go
that
look
one?
at that one, then
Okay.
explain, as you explain what you're talking about there,
Okay.
let's put it in context.
That one. No, the second one. That one. Okay. This diagram is the exhaust treatment system, and the problem being is that the majority of SCR systems has the CO treatment in front of the SCR bricks. We have, if you look at the SCR housing portion of this diagram, you have OxyCat CO removal on the back end. The gas flow, of course, comes in.
Say you have the what now?
It's called OxyCat. That's the oxidation catalyst.
I'm looking for it.
Okay, it's at the very end of that SCR housing diagram at the bottom.
Okay, fine, I got you.
So the gas flow comes in through the top of that housing. In the mixing tube, the urea goes injected into the SCR, and then it goes through the SCR first. Then it goes down through the oxidation catalyst.
Okay.
And the problem being there is that the urea coming through the SCR is, first of all, we have a distribution problem that has been identified. So there is ammonia slipping through. The ammonia that slips through goes through the oxidation catalyst and is oxidized to NOx.
Okay, and that's why you have that sampling point there.
The sampling point has to do with the control of the SCR system, because you have to have a feedback control system, and that's why that sampling point is there. But the sampling point that we determine compliance is the RADA sampling point on that diagram, and it's after the oxidation catalyst where there has been oxidation of ammonia, and it thereby increases the NOx.
Well, you have this region stratification entering the catalyst, and what comes from that is a static mixer ineffective.
Correct.
Did you explain that again for me?
Yes, sir. That gas mixing tube, that diagram that's shown up there, it is not adequately mixing the urea such that it is dispersing evenly through that SCR housing. What's happening is that it's just really dispersing through the top of it. Like if you poured something down the side of the wall, that's pretty much what's happening. FERCO has discussed this with us, that they feel that they can change it, redesign.
With the district speaker, I'd like for them to comment on that, the inspector, what he knows about it, or when is the appropriate time.
When a witness is presented, you can do that.
Okay, very good. And yeah, you covered the startup issues, initial startup issues, pretreatment system. Go through that again.
Okay, we started up in 2016. We had a number of issues. Let's see here, if you go back through. Okay, we started up in February 2016. Just with any normal startup of a large facility like the Bowerman Power facility, we had issues coordinating your pre-treatment system with your engine system, with your post-treatment system, just getting them all to work together and to meet the emission limits was a challenge. So we had a number of problems which were identified when we tried to do the first RADA. Okay, when the RADA was, the ASIMS was installed into our computer system, and Rockwell tried to model it. they found these control problems with the SCR, where the sample probe was in a location that didn't it didn't show the response of a typical SCR. As I mentioned, the typical SCR systems has a CO catalyst in the front. So during that ASIMS RADA was identified that they could not model our system. It led to a number of other problems. Well, that was the one problem with the RADA. We had to reconfigure the sampling location for the SCR. So in the interim, prior to trying to reschedule the RADA, we were working with the SCR developer, manufacturer, Stoiler, trying to get them to help us understand the control system and help us modify the controls and the sampling system, which they did. They worked with us. It took a number of months. They're in Germany. It was...
Did you modify the SCR, or what did you modify it?
We modified the sampling system. We changed the sample location from after the oxidation catalyst to right after the SCR catalyst, but before the oxidation catalyst, so that we can get a more accurate NOx reading.
Okay. Now, you also met with the district, and what role did the district play at that point?
Well, we
You
met...
had all these problems with the district.
Right. We were sharing with them our startup issues, and a lot of it had to do with the ASIMS RADA, because we were unable to really reschedule that until we got the SCR control problems squared away and worked out. And so that's what we discussed with them and told them our findings on how the SCR sampling system needed to be changed, and discussed the timeline on working with Stoiler, located in Germany, as I mentioned, and the time frame.
When you share these flaws, design flaws, configuration design flaws with the district, did they have any comment at all?
Did
the district have any comment?
They understood that we are working with new technology, because there's not a lot, there's very few SCRs that are on the back end of landfill gas. It's a known fact that siloxanes will poison SCR from landfill gas. And so that's, they understood we are working with a new technology.
Well, we have other landfill gas collection sites in the district, in our jurisdiction. Why is yours more difficult than theirs?
There's no other landfills in your district that are meeting the 11 ppm right now.
And that's the difference.
We'll present a witness.
Please do. All right, thank you.
Any other questions, board members? Do you have another witness? Mr. Hines?
I do not, but can we go off the record just for a brief moment?
Yes, we're off the record.
Back on the record.
We're back on the record, and the senator had one
If there are
further question.
There are other landfill gas collections in the area. Why do you feel obligated to go the extra mile?
Well, we had to meet 1110.2 rules in order to obtain a permit for a new landfill gas facility with internal combustion engines, after the district had implemented that rule 1110.2. There's, like I said, there's only 2 other engine facilities have filed for permits under that new rule, and they haven't even conducted their compliance test yet.
So the district, thank you.
Thank you. Mr. Hines, did you have anything further?
I do not.
Thank you. Ms. Reichart, yes.
The district did have some questions for their FERCO representative, so I can call them, unless you want to call them, and then I'll just ask questions. I don't know how you want to work that.
We can do that.
Okay.
Yeah. It may make more sense for me to call that witness and then just do some introductory questions, and then you can
That
proceed.
sounds,
Does that make sense?
that sounds good. Thank you.
Okay, great.
I do believe that more than just Ms. Frank took the oath, so let's make sure, though.
And actually, if we could just go off the record briefly, so I could just talk to my witnesses about what I need to find out.
Yes, we're off the record.
I'd like to go off the record to talk to your son.
We're back on the record. Mr. Hines, if you wouldn't mind introducing the witness from FERCO.
Yes, thank you. Dr. Muzio will testify on behalf of Bowerman Power. Dr. Muzio, would you state and spell your name for the record, please?
Lawrence Muzio, Lawrence
And did you take the oath?
Yes, I did.
And I will refrain or hold my questions for redirect and allow Ms. Reichert to proceed.
Thank you. Dr. Muzio, right?
Larry is
Or
fine.
Larry. So if you could bring up, I don't know what page it is, this page of the. So can you explain why the sampling point is at that location? Because if you're getting higher NOx, or if the oxidation catalyst is oxidizing the ammonia such that it is then increasing the NOx levels, shouldn't the sampling point be after that oxidation catalyst, because that's what triggers and determines the urea injection levels?
From a compliance standpoint, correct, but as Sharon Frank pointed out, that sampling location is used to try to control the urea injection rate.
Right.
So if that was located downstream, you add more ammonia or urea, the NOx goes down, but the ammonia slip goes up. The ammonia slip goes across the CO catalyst, oxidizes. You actually measure a higher NOx coming out, so that tells the control system to put more in. So it's just an untenable location to use as a control point. So that sampling location is used by Stoiler to control the urea injection rate.
Madam Chair, we have an expert witness. It'd be beneficial for me if you had this on the board and you were pointing to what direction things are taking, if that's all possible.
I don't believe that's possible, only because
don't-
it's
This
not a
diagram,
hard copy diagram.
But we do have a.
Oh, we
hard-
do.
We
Oh,
You-
you have a laser pointer?
yeah, pointer, yeah.
Yeah, you could do that if that
we
works.
have a laser, does anyone have a laser pointer?
I didn't bring one.
I have a. Oh, and then you could just point to the, on the camera itself, so. This mine is clean, if you want to use.
She has one. Ms. Reichert? She found one.
Oh, no, because so she can use this,
You're right.
so that way, so he can point there.
No, I meant he found a laser.
Oh, so he could just, but then you guys have to turn around, I guess it doesn't.
Or right
It'd probably be
Yeah, this way you.
best to do it, that way everyone can see it.
Up there, right? Oh, it doesn't work on the, and it doesn't, so it'll go up, but it should up here, because this is a,
I think that's a much better idea. Thank you.
what do I have to do? Do I have to turn it on or? I don't know. What do I have to do? There should be a button at the bottom.
I love this. You're dealing with hundreds of millions of dollars of technology, but you can't get this working.
I'll turn it on for you.
Oh, wait, so it is on, but it's not. How does it go up there? Wait. I have. There it is, there. Oh, there. No, so it's still going up there. It's not going up there. It's on the screen. Right, so that doesn't change anything. So we're back at the same place.
You use your finger.
Use your finger on this. Okay. Way old school. How many people does
Hey,
it
you wanna use
take
this,
to figure
wanna use the
this
pen?
out?
You wanna use the pen?
There we go.
Use that pointer as a pointer.
I don't know why it was so hard. I couldn't quite figure out how.
It's not intuitive.
Yeah, I don't know. Okay.
Oh, can you turn that microphone on and pull it towards you? Thank you, because we keep an audio recording of the
Okay.
proceedings. That way you'll be recorded properly.
So the urea injection rate is directly tied to not the NOx emission rate, correct?
Well,
Or not? If,
Wait,
please
say that
correct
again.
me. So the determination of the appropriate urea injection rate is tied to the NOx emission rate.
correct.
Okay, so if you have more NOx emissions, you would then want to increase the urea injection rate?
Correct.
So since you're getting additional NOx emissions after the OxCat CO removal, So then wouldn't you want the sampling point to occur at that stage because you have increased NOx in order to trigger additional urea injection?
Yes, but if you, if you're sampling down here and you've already reduced the NOx to almost as low as it can go based on the amount of catalyst that's in there and its activity. So now you have ammonia slip present. It goes across the CO catalyst. It gets oxidized to NOx. You're sampling down here and saying, okay, the NOx isn't as low as it's supposed to be. It's not 11, it's 20. That tells the control system, add more urea. It adds more urea here, but the catalyst can't reduce the NOx anymore. So now you have more ammonia coming out, which gets oxidized, and it actually drives it up. So it's just, you can't control it.
So my engineer has advised that a more typical setup is to have the OxyCat before the SCR.
Correct.
Okay, so would that help? Because then you have the possible addition of more NOx at that point, and presumably maybe the SCR could remove some of those additions, some of that additional NOx.
If you're going to move the oxidation catalyst, you're going to put it ahead of the point where you inject urea.
Okay.
You're not going to have the urea go
Okay.
through the oxidation catalyst. It'll just make more NOx.
Okay. So why would that not be feasible?
It is.
Is that one of the possibilities?
A number of potential solutions that we're starting to see that are worth considering. But yeah, that is one of them.
Okay.
Now, then we have to ask, what we found out, just got some of the results yesterday. We operate a laboratory in our offices in Laguna Hills testing catalyst, and we've tested each of the layers of catalyst that are currently, that have been in the engine 3 since January. And the deactivation rate is very high.
Let's talk about the deactivation rate. What is that? Is that caused by the stratification or by siloxane buildup?
Siloxane.
Okay. And so have you come up with any ideas how to reduce the siloxane buildup?
We haven't, that's not an area that we're really expertise in. I think that Montauk is going to have to take a look at maybe adding a polishing step to the current siloxane removal, but that's really out of my area of expertise.
Okay. And I had asked Ms. Frank this. Can you talk about, so obviously you're trying to achieve lower emission rates with this system than other similar systems in the district. Can you discuss what's different about the setup or the, emission reduction systems that is meant to achieve those additional reductions? How is this setup or any of this different in the hopes of achieving those reductions?
Well, compared to a system where you don't have to achieve?
You don't have to have such low, yes.
Okay, with SCR technology, the higher the NOx reduction that you need to achieve, you're always facing an ammonia slip limit. With a higher NOx reduction, you've got to have a more uniform distribution of ammonia to NOx entering the catalyst to limit the amount of ammonia slip coming out. So, in fact, when we first saw this sketch with the static mixer, we said, oh, great, the distribution into the catalyst is probably going to be very good. Did some tests looking at profiles coming out and said, oh my goodness, this static mixer isn't working very well.
Is that static mixer different than other systems?
Oh, they're all different. And every manufacturer has their own version of a static mixer if they use one. We've seen a myriad of them.
So you saw this static mixer and thought, oh, this should do a better job of evenly distributing the urea.
Well, we didn't know what the details of it were, but we saw this schematic saying it's got a static mixer. And in most cases, when we see a static mixer with an SCR unit, we characterize the the degree of mixing by a standard deviation. And usually with a static mixer, we'll see that standard deviation be down in single digits. The one we characterized on engine 3 is at 18.6%, which is not very good.
Is there any difference in the SCR brick layers in this system versus others?
No,
No? And then it sounded like this OxyCat CO removal location is different. Was that in an attempt to achieve compliance, or was that just the way the system was?
we'll have to ask Stoiler. I would never have put it there.
Okay. Okay. Give me just 1 moment.
While you're waiting, Dr. Lerner, I think you had a quick question, as a clarification question.
You mentioned static mix, excuse me, you've clarified a lot of things to this, for me. The question I have for you is there such thing as a kinetic mixer? You say a static mixer, which means that there are fins there, and that's causing the mixing. Is it not possible to use something that is driven, that is in motion? A Cuisinart, so to speak, for you.
Keep in mind that this gas is at 850 degrees Fahrenheit. So that would, I'm not aware of anybody that's tried to do it with a kinetic mixer to affect this kind of mixing. There are designs that could be retrofit in here that I think would probably give very good performance.
Thank you.
Ms. Reichart, do you need a minute?
I think that's all the questions we have right now.
Okay, then I'm going to ask Mr. Hines, do you have any any questions of your own?
This is my friendly witness, but
Yes.
I have a couple of questions for the clerk. Would you state your title, please?
At FERCO,
Correct.
I'm a vice president.
And you work at FERCO. Can you say what that stands for, and then also provide the address of that business?
Fossil Energy Research Corp. We're at 23342 Suite C, South Point in Laguna Hills, California.
And just a couple of questions about the assessment process. Ms. Frank testified that you and your company have been out there currently. That work is continuing and expected to continue for some time. Is that correct?
Correct.
And you're still at a stage where you're generating preliminary observations, but no real findings as yet. Is that correct?
Well, we have some serious hints on what's going on. I think we've characterized a couple of the engines. I'd like to characterize a couple more to see if they're consistent. For instance, the maldistribution that we're seeing on engine 3 that we characterized, I'd like to do that on at least 2 other engines to see if it's all the same or if it's even different between the engines. So
It's fair to say then that you've been fast-tracking this and you've made a fair degree of progress in terms of identifying what may or may not be going on?
I think so. We're going as fast as we can.
And there was some testimony and some questioning about short variance versus regular variance. To the extent that Bowerman finds it necessary to seek a regular variance, would you be prepared to come back and present further observations, findings, some conclusions to this hearing board?
Certainly.
Thank you.
Board members, do you have any questions? Senator.
This configuration here that I see that you explained, Doc, you talked about moving the OxyCAD up between, in that area to make some adjustments with the emission. To make some adjustment with the emission there, because you're trying to meet a certain goal.
Yeah, I think to prevent the problem they're having with.
Is your microphone still on? Oh, maybe it was, but you weren't talking directly into it.
Moving the oxidation catalyst ahead of the urea injection point will take care of the issue of oxidizing ammonia slip to NOx, so that solution, that would fix that solution. Still have to deal, then I'm going to be concerned with what the siloxane is going to do to that oxidation catalyst. So, and there are a couple of other possible solutions. There's some new catalysts that a couple of vendors have come out with that are a so-called dual function catalyst that will deal with both the NOx and the CO at the same time. That's being applied recently to some reciprocating engines. There's an ammonia consumption catalyst that can be located between the SCR catalyst and the CO catalyst that may deal with it. So there's a few options that need to be studied and a recommendation made.
Is it true to say that your final configuration or design is not before us today, so it could change?
Correct.
Therefore, if we accept what's before us today, what's the likelihood of it meeting the source test once it's done? Because you got to meet a source test.
When all the modifications are made,
As of today,
I still don't.
when the modifications are made, okay, all right, go ahead.
I think it'll be able to pass the source test.
Within the time frame?
To be honest, I think they're going to need a.
I want you to be honest all the time.
Probably, by the time, I think there are going to be some changes needed to be made to the system, and those could take upwards of a year.
A year. Yeah, just to make a statement, you've done good for me. Sometimes we don't ask enough questions, so we have questions unanswered, and yet we make decisions. But I have to have the questions answered and then asked and then answered. If this is not going to meet the requirements within the time frame, where do we go from here is the question. I would like from this.
Let's stick to, because I have similar issues, and I think that's for discussion, but do you have any other questions for this witness of a more technical nature?
What's your expectation in terms of when you titrate the system, you trial and error, basically, try to get it operating within the limits?
No, we're not doing anything.
11.1002, huh?
We're not doing anything by trial and error out there.
Well,
Our efforts to date out at the site have been to really try to understand the problems.
Go ahead.
And we are. We've been able to define areas that need improvement, and when we're got enough data, then we will make some recommendations to remedy the situation.
In your professional opinion, when you find that some improvements need to be made, and when you make those improvements that you think will be forthcoming, will it cause anything else to be out of balance?
I didn't quite get that.
Will it cause something else to be triggered where you're not meeting?
I don't think so. I think the issues are pretty well defined, and I think there's some pretty standard solutions that can be pursued and to get the system working properly.
But you have not come up with a final decision to tell us that the system will be working properly.
We just started this assessment. We're still trying to understand all the problems. And whether or not they're engine specific, there's 7 engines out there. And we've got tests on maybe 3 of them so far, and not even comprehensively on 3.
That's not
comprehensively on 1.
Okay. So, got to do maybe one comprehensive. What is a comprehensive test on one? What does it consist of?
One, we have to set the engine up so that we can obtain an NOx profile at this location, at the exit of the SCR catalyst. Mm-hmm. That takes us almost a day to go through to get that. We like to run another test where we have to put additional probes in at the exit of the SCR catalyst, not just one, so that we can get representative numbers and then see how the catalyst behaves as we change the urea injection rate.
It takes another day.
It takes us about another day to do that.
And what else you have to do?
Then, again, it'd be nice to take another set of catalyst samples out of another engine, analyze them in the laboratory to see, to assess their rate of deactivation.
Going through the same process?
Pardon?
Going through the same process?
Yes, that we've already done on Unit 3.
Isn't that trial and error?
That's not trial and error.
Okay.
Ms. Bird, did you have questions?
Yes, thank you. Dr. Muzio, have you done anything, or how do you relate what your company has done to this type of project that gives you confidence in your recommendations?
Oh, we've been working in SCR technology, selective catalytic NOx reduction technologies, since in the 80s. SCR technology was first put on the large utility boilers in the LA basin in the mid-90s. We did a lot of the physical cold flow modeling that's done to design these for a German company that did a lot of the installations. During the 2000s, SCR technology was deployed on all the coal fleet throughout the U.S. We did about 50 cold flow models of SCR systems to support their design. We do a lot of balancing of the ammonia injection grids on these large coal units. For the last year, we spent almost all year working with two vendors on 8 large combined cycle units that went in on the East Coast that 4 of them couldn't comply, and we got hired to figure out why and help them define changes to be made. We did that, and they're now in compliance. We wrote for the Electric Power Research Institute, which is a research arm of the electric power industry. We're the contractor that wrote the catalyst testing guidelines for coal catalyst under laboratory conditions. And at the end of 2015, did another project for them defining testing procedures for gas turbine, CO, and SCR catalyst. So we work in this whole catalyst area day in and day out.
Okay. Then I had another question. As far as guarantees go, do you have with Bowerman any type of guarantee as to what you're going to provide for them?
No, other than
just the research.
Our reputation and transparency in terms of coming up with what we think are good engineering solutions.
Okay. And you have no relationship to this company, Stuhler?
No.
Okay. Okay. And you made a comment about something to the effect as going as fast as you can. Exactly what is that?
Well, we're trying to get these tests done as fast as we can. We're a small company. We have some other projects that have been on the books, and we can't abandon those customers at the same time. So we're putting as much resources as we can on this project.
Okay. So you have seen the proposed variance conditions, at least for the dates that are being projected as to when things will be completed?
Yeah.
And you believe that you can meet those?
Correct.
Okay. Thank you.
Dr. Lerner, you had a question?
You mentioned about siloxane, and some of that is coming over into this input here. Aren't there siloxane polishers? If I remember correctly, we had some hearings here regarding oil refineries, and they use siloxane as part of the purification of the gas. Is that a possibility here? You mentioned it in passing, and could you just elaborate on that for a moment?
Well, this system has a siloxane removal system on it. I don't know what the inlet levels are, but it's my understanding that the current system takes it down, takes it down to about a half a part per million siloxane in the gas that goes to the engine, maybe 0.2 to 0.5 parts per million, but the question is that low enough?
That's what I was going to ask.
Well, no, I think if the deactivation rate that we've measured so far is consistent with all the engines, then I don't think it's low enough, to be honest.
Thank you.
Senator.
Right. Doctor, I compliment you. You show me you have a lot of experience in R&D on projects like this. To your knowledge, is there any other project like this in the U.S. that you know about?
No.
Would you consider this an R&D project?
Not really.
Why? Come
A lot
on,
of
Doc.
times when there's
Come on, Doc.
some things come up, no, this is not an R&D project. This is straightforward. We know that we need to achieve the level of NOx reduction that we need. We know what kind of uniformity we need going into the catalyst. We know how much catalyst needs to be there. The one surprise we had was the location of the oxidation catalyst. And the unknown, and I'm not an expert on it, is how low does that siloxane have to be in order to provide a reasonable deactivation rate for the catalyst?
You're trying to meet a new standard 1110.2, and it's never been done before. And so therefore, you're trying to find a way to meet those more stringent requirements. Am I not correct?
Well, that's the goal of this system.
Right. And so there's a new responsibility imposed on this client petitioner to do something that has not been done before. And that's the first approach. Is that not correct? To your knowledge.
On this specific application, yes.
In my business where I'm from, they call it R&D.
Okay.
Okay, thanks.
Senator, is that, yeah, okay. Any other questions? Okay. Mr. Hines, did you have some questions for your witness?
I do not have any questions.
Okay, I
for
thought
this
you were.
witness. But I do, before you deliberate, I do have a.
We're not ready to deliberate. I know Ms. Frykart wanted to produce witnesses. I would like, and unless there are other questions, I'd like to take a break, and I'd like to come back in 15 minutes. And at that time, before, Ms. Frykart, you bring on your witnesses, I think I'd like to discuss a legal matter so that we don't waste time if that legal matter can be decided before witnesses are brought on. Mr. Hines.
To the extent that that legal matter involves the procedural posture of this matter, I might want to put on Ms. Frank to sort of clarify some of the colloquy that we've had about being able to come into compliance within the short variance period,
Okay, I
if
thought
that's appropriate.
we had significant testimony on that already, which is why I feel it's appropriate to make that legal, have that legal discussion. Is there testimony different from what we've received from both Ms. Frank and
And Dr. Muzio?
Dr. Muzio?
I would not characterize it as different, but I think that I can offer. I think that through questioning, we can offer a perspective that perhaps is not clear right now, is the way that I would like to put it.
Will it be a lengthy questioning?
It will not.
Okay, because that opportunity was, but,
I understand.
okay, if it's not lengthy, then I think we can do that when we come back.
I appreciate. Well, okay, all right.
Okay,
Thank you.
so let's go out, let's take a 15-minute break. Let's come back at 2:15. Thank you. We're back on the record, and before we left, I had mentioned that I think at this point, since petitioner is done, with the exception of perhaps a 5-minute question and answer with the affirmative case, I think it's appropriate to discuss the legal issue at this time. But Mr. Hines, since you requested it, I'm going to give you some latitude to briefly ask some questions along those regards. And it is the procedural posture of the request for a short variance versus a regular.
Understood, and I appreciate the latitude, Madam Chair. I want to recall Ms. Frank and just have a couple of clarifying questions with her with respect to the issues that have come up associated with the petitioner being able to achieve compliance within the 90-day time period. And Ms. Frank, my specific question for you is we were talking during the break, and can you relate for the hearing board basically what Bowerman Power might be able to do to achieve compliance within the 90-day period?
Okay, within 90 days, we could come into compliance. There's a few things we can do, talking with FERCA. We can possibly change out all of our catalyst in every engine. We can purchase and insert this ammonia consumption catalyst after the SCR. We can modify the static mixer to see how that works, and we can also change the PLC controls, we feel, to insert a NOx analyzer on the engine exhaust and change the PLC on the spoiler system so that we can adjust the controls into a system that FERCO is more familiar with and has more success in controlling NOx. We can come into compliance within 90 days with these things. Is this a final operational fix? Not necessarily. We feel that, down the road, we would still continue to work to try to identify what an operational fix is. You obviously can't change out catalyst every 4 months and can expect to operate within a, economically and a feasibly, operate a facility. So these are things we can do. We feel that we can do within 90 days.
Thank you.
Ms. Reichert, did you have any questions on that line of questioning?
Are you going to do those things?
Yes, if we believe we can, yes. We're going to, yes.
Okay, thank you.
I have a question. Ms. Frank, I asked you earlier, if you thought the time frame was more likely to be along the 1-year time frame as was presented in the regular variance petition, and the answer was yes. Have you changed that?
I am not changing that answer, but clarifying it to the extent that, yes, there are things we can do to come into compliance within 90 days. Is that the operational fix for this facility? Not necessarily. Okay.
When you say can you be a little clearer as to what you mean? Do you mean there's a possibility that any one of these might fix the problem? Or do you mean we do this and then we can be in compliance? You see the difference there, and
right.
Sorry, I keep forgetting the doctor's name. Dr. Musio seemed to testify that they were in the very beginning stages of their review and recommendations, and that it's likely that could take upwards of a year, was his testimony. Do you not agree?
The year, I believe that, I don't want to speak for Dr. Musio, but the year he was referencing was the installation for the redesign, relocation of the CO catalyst up front of the system. And again, that time frame would be to come to a final operational solution, something that is workable. Again, to implement these changes may bring the facility into compliance within 90 days, but it may not be sustainable. Okay, and that is the solution. We are looking for a sustainable solution that, is ultimately is what we were referencing. But there are some things based on his preliminary findings that we think we could implement in that time frame because he has identified them already.
When you say it's not, may not be sustainable, right now, the issue is sporadic exceedances, isn't that correct?
No, ma'am. Right now, the issue is continuous noncompliance.
Continuous noncompliance, okay. Okay. So can you just further define?
With the 15-minute average, that's correct.
Can you just further define sustainable? And what is the percent? I didn't hear testimony that there are fixes that have already been suggested and could be put in place right away that would fix this problem, even in a short term.
The items that FERCO has observed are based on his experience, would bring this system into compliance. Based on those observations, some of them could be implemented in a faster time frame than others. So there's some things that could be implemented within 90 days, but not everything.
Okay, what we're looking for is, can compliance be achieved within 90 days? Because yes, you could implement a suggestion, but I personally, I'm not sure I heard testimony today that implementing the suggestions that already exist within 90 days would bring you into compliance.
The very first corrective action that I mentioned was to change out all of the catalyst. FERCO did basically one of the first things he did was take all the catalyst out of engine 3 and put brand new catalysts in, and he gave us results that showed that brought the engine into compliance.
For how long?
Well, it's still in compliance.
And how long ago was that?
That was, let's see here. I want to say August 2nd it was installed. Yeah, 1st or 2nd, August 1st or 2nd, a new catalyst was installed.
Is that really the long-term? I understand you're saying there's a difference between the long-term and the short-term fix, but if I look at Exhibit 4, which was your presentation, and I look at the FERCO observations, we see catalyst deactivation. Field data suggests rapid deactivation. CO catalyst located downstream, that shortens the catalyst life. So replacing the catalyst is not just a short-term fix, it's not really the fix, because those issues still exist, isn't that correct?
But to answer your question, it can get us into compliance.
Okay, but compliance means compliance. And will you still be seeking a regular variance afterwards?
I think if the question is, can we get into compliance, it is yes. We would, again, I think, as I mentioned, the long-term operational solution will take longer than 90 days.
Okay, thank you. Anyone else have a question?
Yeah.
Senator?
Is it cost effective for the short-term fix? You have to replace all the SCRs. Is that considered a short-term fix for a short period of time? And if you did them all, each and every one of the engines is going to cost you a lot of money. Is that the reason why it's called short-term rather than long-term?
It's not cost. It costs, currently what it costs is $473,000 to replace all 4 rows of bricks. That's how much it costs.
Well, then fine, you'd be in compliance.
Correct.
If you did that, right?
Correct.
So what's the problem?
That's how much it costs.
You said that that's not a long-term, but you said it's not a long-term fix. Is that not correct?
Well, we would still continue with our study to try to understand what else we can do to modify the system.
If the system is operational within the guidelines of 1110.2, what does you have to do?
Well, I think we would want to study the system so that we can extend the life of the catalyst and operate it on a longer-term basis than to have such a rapid degradation that we are seeing.
What's the life of the catalyst operating at that rate?
At this rate right now, it would be less than a year. We just installed new catalysts in January.
They last about a year, maybe at most.
I think it would last less than a year.
We have the doctor back there. Maybe he could address the issue, the fix that you already talked about. If it's okay, Madam Chair, to have him respond to that?
I mean, I want to avoid calling and recalling witnesses, but, I mean, we can go back and forth between these witnesses, but is there?
But he's the expert. He's the scientist. He's an expert witness. They brought him here.
I understand, and
she
he
talked about
already
a fix.
testified, as did Ms. Frank.
He didn't talk about a fix. She did to the problem. It's all, and
Dr.
what should be done to fix it.
did
Yeah,
testify as to a fix.
but he thought he was going to groping for a fix. Try this, try that, try that. That's trial and error. Even though he didn't mention it as such, it's like research and development.
I think we have that answer. Is there, do you want to ask it again? Because we can go back and
I
forth.
want to ask him if what's being proposed by Ms. Frank is a fix to the problem, and if so, what's the time frame? How long will it last? Duration?
Okay, hold that question, please. Ms. Byrd has a question for Ms. Frank.
How long would it take to replace the bricks, you say?
It takes 2 days. Well, you have to shut the engine down, bring the heat down, and then install the bricks in. It takes about a day of downtime and then a day approximately to change the bricks.
So 2 days and you'd be in compliance?
Yes.
Okay. That speaks to something else that we usually do, and that is variances are to work toward bringing you into compliance. So if you're in compliance, but then that variance may not be issued we might not issue it for that long period of time if you can come into compliance that quickly.
I recall, Madam Board Member, that last time we were here that you indicated that if we went for the variance, we could always change it if we came into compliance.
You can pull it.
Right.
Yeah, if you issue a variance, you can pull it. But I guess what I'm saying is when we issue the variance, we determine based on the information that's presented at the hearing, how long the variance should last. Mm-hmm. And even though this is a short variance, that doesn't mean that we automatically issue a short variance for 90 days. We look at everything together to determine how long the variance might last.
For the other corrective actions that we indicated that were based on the preliminary results of FERCO, it would take us 90 days to insert the ammonia consumption catalyst, to first locate it, purchase it, to make sure it fits into our housing. With regards to modifying the mixer, it would take 90 days, as well as the PLC controls, so we would have to purchase the NOx analyzers, have them installed.
Okay.
Whenever you're done, I had some more follow-up questions.
Why don't you go ahead?
Okay. So if you replace the catalysts, would that on its own bring you into compliance with the emission limits?
Yes.
And would you be able to maintain those emission limits while you took the other corrective actions and continued the studies to determine long-term fixes?
Yes.
Would you agree to adding conditions to that effect on our proposed variance conditions?
If the district feels that those conditions are warranted, yes.
Okay. Okay, I think that's all I have. Right. This is this is a new development. So
Now I'm back to the question Ms. Byrd was asking, which is, if the answer to replacing the catalyst puts you in compliance, then why do you need 90 days to do the other fixes on the list? If you're in compliance, you're in compliance. You don't require a variance.
Because we need a long-term solution that we can live with. As Dr. Muzio testified, the studies that he has initiated, we need to understand why we're having rapid degradation of our catalyst. A catalyst, SCR catalyst, should typically last you 3 years on a regular natural gas system. It's degrading much quicker than that.
Understood, but do you understand that the answers that are being given are in conflict? Either you require, we don't grant variances just to go out and to attempt to remedy issues. We grant variances from emission limits. So if you're not exceeding the emission limits because you change the catalyst, you no longer require variance relief, and you can do the long-term studies as you want. So either this fix will put you into compliance or it will not put you into compliance. So you see the rub.
Can I ask one more clarifying timing question?
Yes. But I think.
Yeah, I just had a question on the 2 days. Does that include ordering, delivery, and everything, or would you have to add that on?
I think we have some catalysts available at this time that we would be able to.
So you'd be able to just go ahead and it would just be installation?
Put it in, yes. But
Okay.
but typically ordering, it is a longer process.
Okay, but do you have enough to replace all of them at this time?
Just a minute. The answer is no. We do not have enough to replace all of them at this time.
How many would you be able to replace?
I can't say right now. That's an operation for operations department.
Okay, and then if you had to order more, how long does that process take?
I want to say 60 days. It's been a long lead time to get the catalyst because we were purchasing it from the Stoiler manufacturer, which is in Germany.
Okay, so potentially in order to actually replace these catalysts to come into compliance, it could be 60 days to get them.
Or longer, yes.
Ordered. But you could replace some of them quickly, you're just not sure how many?
Correct.
And would just replacing those few bring you into total compliance or just bring certain engines into compliance?
It would bring the engines with the replaced catalyst into compliance.
And if you replace 2 out of 4, let's say you could replace 2 out of 4 out of all the engines, would that bring you into compliance? Because there's 4 per, right?
There's 4 rows per engine.
Yeah. So like would replacing some of them on all the engines be able to bring, or you have to replace all of them, you think?
Again, that is really a part of what Dr. Muzio is attempting to do. I really can't speak to that if
Okay.
that's going to happen.
Okay, I'm just trying to understand.
And do you have any idea, based on the recommendations of Dr. Muzio or on the experience, of how long that catalyst would then last before you had to replace it again
We
to
do.
stay in compliance?
We do. As a matter of fact, he gave us some deactivation information, catalyst activity the catalyst he pulled out of engine 3, and he showed us that it would be less than a year. It's more on the order of 6 months that it would lose its activity. It would lose about 50% of its activity within 6 months.
Any other questions from Dr. Lerner?
Just to reiterate a point, almost to redundancy, is this mostly due to, or entirely due to, or very little to do to the siloxane?
That it has, I think, a lot to do with the siloxanes.
So, okay, so may I conclude this answer this if this is out of line? The issue is not the catalyst. The catalyst is the degradation, the decreased half-life of the catalyst is really a function of what's coming into the catalyst. What's coming into the catalyst is a whole mixture of things, including siloxane. Are there any other things that are coming in that could cause degradation? And what steps are you looking to do to get these things out of the loop?
Okay, it's not as simple as just the siloxane problem. As Dr. Furco has mentioned, it's siloxanes plus the distribution of urea plus the control system plus the configuration, okay, of the CO catalyst. So it's all of those
I understand the
combined.
mixing issue, I'm sorry. But I just want to know, then let me phrase the question this way. Can you just enumerate, it's right off the top of your head, as many factors that you currently know that are causing this? Because if we replace this, you're in compliance, but you're going to be out of compliance, you're going to be back here. So I need to have an idea as somebody who wants to try to be helpful, and for me to understand it, and everybody else to understand it, what are these factors besides siloxane and the mixing situation?
Well, I think that Dr. Muzio outlined many of the factors. It is the stratification of the urea. It is really the location of the CO catalyst downstream. It is the SCR controls in and of themselves. They need to be changed so that we have an inlet NOx analyzer that loops back to the control in order to control the urea adequately. And then the siloxanes. I want to say the siloxanes on the last. So you have like 5 things there. Finally, we have the ASIMs. The ASIMs are a back-end problem on monitoring it because we have to calibrate them monthly.
Question, follow-up. What about moving the, okay, I'm getting tired now and I can't use these words because I can't see the picture, but moving the device that does monitoring for you, was it the OX? I'm sorry.
The Stoiler sample location?
I'm sorry?
The Stoiler sample location?
Yes. Moving any of these, can that be done simply, or is that a difficult thing to do, to take it in one place and put it into another?
The CO catalyst is, if I'm understanding your question?
Yes, the CO2 catalyst, and also there was one other thing that you mentioned, one of the 5. No.
It's not, the most complex fixes right now would be to take that CO catalyst. We'd have to build a whole new reactor on top of the engine housing in front of the urea injection mixing location to put the CO in. In addition to that, we would have to consider a guard catalyst configuration. So those are things that it's feasible, but it is costly and it would take time and engineering to accomplish.
That's what I'm concerned about, the time and engineering. Do you have any estimate about what you said you might have to do, how long it would take?
Well, that's just one of the fixes. The fix that I mentioned that could be accomplished within the 90 days is the ammonia removal catalyst that can fit into that SCR housing.
And how long would it take to do that?
Just a minute. We would have to find out the availability of that ammonia removal catalyst. And
Okay, let's say you have it in the trunk of your car. How long would it take it to put it where it belongs so it could work?
I would say at least a week. I would give it an estimate because we would probably have to do some modifications to the housing to fit it in, or if it fits into one of the existing layers, there are spare slots in there. So it would likely fit into the spare slots that already exist. So, yeah.
Thank you. I didn't mean to, I don't mean to put you in a corner, but I'm just trying to get a better picture of this issue and the duration of the variance that we're looking at, within the 90-day frame, okay? Thank you.
If there are no other pressing questions, Senator.
Don't you worry, I'll release you from the corner. So in any case, let's go back to the unanticipated SCR control issues. That's what we're talking about. And the bottom one saying neither the treatment system nor SCR used in this project has been previously used in this specific application. So if you haven't used this application, what assurance you have that it's going to work for a year?
Well, one thing we do know, that Stoiler sampling point, okay, it's not our compliance sampling point. The compliance sampling, the RADA sampling point is after the CO catalyst, but that Stoiler sampling point is in compliance every day, all day. That Stoiler, I don't know, can I point on it? Yeah. Yeah, the Stoiler sampling point is in compliance. What the issue is, the RADA sampling point with the extra oxidation is out of compliance. That's the guarantee that we have. We know that those bricks are really in compliance. I mean, we're meeting compliance at that point. If we could move our RADA sampling point to there, we would be in compliance.
Let me ask you, Terry, what about operating temperature? Is operating temperature cause the SCR to degrade quickly? No?
No, we are operating within the range as specified in our permit. We never have an issue with that.
What's the specs for operating temperature for the SCR?
It has to be above 572 after it starts up, and we have like a half an hour to start up. Those engines, they start up, it's a minute. They go from 0 to max power.
Thank you.
Okay. I think it's time. I'd like to start a discussion on the board, between the board members, of what's being requested and the procedural legalities of the procedural posture with which it has reached us. And in particular,
Madam Chair,
yeah.
we're going to ask the inspector any questions?
If you would prefer, I mean, we can, let me ask, how long would your...
I have only a brief question that I'd like to get answered about the regulatory scheme and why this facility is required to comply, and then whatever questions the board has. I have both an engineer and an inspector here. I'm just going to start with the engineer, and to the extent you have additional compliance questions.
Okay. So since we don't know how the discussion that I want to have of legalities will go, let's just go ahead and finish up with the district witnesses so we can finish the hearing.
Thank you. The district calls Ray Ronquillo. Could you please state and spell your name for the record?
Ray Ronquillo, first name spelled R-A-Y, last name is R-O-N-Q-U-I-L-L-O.
And what is your position here at the district?
Air quality engineer.
What's your actual title? They need it for the...
Quality engineer.
Is there, that's it? There's no there's no numbers or anything after? Oh, there you go, 2, see? See, we have to have the 2. You gotta have the 2. And did you take the oath today?
Yes, I did.
Can you please explain why this facility so far is one of the only facilities that needs to comply with these limits?
Actually, based on the most recent amendments to Rule 1110.2, every facility that installs a biogas engine that's not used for emergency purposes would have to comply with the limits stated in that rule, which would be 11 ppm for NOx, 250 for CO, and 30 for VOC.
So no facility, though, yet has demonstrated compliance?
At this point, there have been several facilities that are in the process of installing a very similar, if not identical system, but we don't have any data yet as far as where their compliance status is.
So a question was raised that whether the facility was going above and beyond what was required. That's not true, right? They are just complying with the requirements of our rule. Or they are attempting to comply with the requirements of our rule.
I would say that's a fair statement.
Okay. I think that's all I wanted to cover, and I know that the board had other questions, but I want to just send it to the board so you guys can get specifically which questions you had answered.
Let me go to Mr. Hines and see if you have any questions.
I have no questions.
Senator, I know you had questions.
My question is, this petitioner is required by the district to do something with landfill gas to electricity that no other facility is required to do. Why?
You mean in terms of requiring to install?
To meet
landfill gas?
1110.2. Why are we requiring it? They have a permit to operate. They were given in August 4th, 2015. That's pretty recent. Then why are we imposing this stringent requirement on this facility when we're not doing it for the others?
The requirements are basically applied to, as I mentioned earlier, any engine that's installed in the district that's fueled by biogas. As of January 1st of this year, we're required to comply with those limits. So they're not the only one that's required to comply with those limits.
And it was just your testimony that there are other facilities currently in development, in construction, that are going to be required to comply with this limit, correct?
Exactly. So any other facility that's currently in construction have the same limits.
What do you mean by construction?
They're basically in the process of installing their equipment, the gas treatment systems and the SCR systems.
What about the system, the equipment that's currently installed? Are they operating under those conditions with that equipment that's currently installed?
I'm sorry, I didn't get it.
Yeah, they're currently operating right now, is that correct, yes or no?
None of them are in, I'm talking about those facilities that I've been working on. But there are other facilities in the district that are in existence right now, but I can't testify to those because I don't know what the status of those equipment are. But for those that I've worked with, they are currently in the construction phase, so we don't have any data at all as far as compliance.
There's some land gas fill, I believe.
Landfill gas.
Land gas fill to energy facilities operating in the district right now.
Yes.
And have been for some time. And they've been before us, but nobody's required them to be this.
Actually, a more appropriate term really is biogas to energy type facilities, because not only landfill gas, but you could also use digester gas if you were in a wastewater treatment type facility. So, but the principles are the same, the limits are the same for any type of biogas.
In the event that this petitioner finally design a model that works perfectly for the intent of meeting 1110.2, could they be used as a pilot program for other landfill?
Yeah, it could be possible, yes.
Well, if that were the case, and they're the first one out of the gate, would they be doing a favor for the district and for the other operators in the area? Could they get capitalized on what they've done here?
I would say yes. It's hard to testify to that, but I do agree that Bowerman Power is probably one of the earliest facilities that actually applied for this type of system, and I believe way back in 2014, right, when they first applied for permits. Yes.
The truth is, the rule was recently adopted, correct?
Amended, yes.
Amended.
Yes.
And this is just the first facility, but many other facilities are subject to this rule.
Oh,
Okay, thank you. Any other questions? Okay, then I'm going to ask if, you had no other
No further witnesses.
Okay, thank you.
Or do I?
Thank you, Mr. Hines. I'm going to ask if there's any member of the public who wishes to be heard. And I'm not seeing any. So, Mr. Hines, I'm going to ask you for your closing.
Thank you, Madam Chair and members of the board. I want to run through very quickly the 6 factors because I think that the testimony today with respect to the granting of a short variance pursuant to Section 40825, that we have presented testimony sufficient for the board to make the requisite findings and to grant the short variance as requested. The first of those, obviously, is that the petitioner for a variance is or will be in violation of any rule, regulation, or order of the district. And while there has been testimony really of late what I'll call clarifying testimony that could indicate that as to certain engines, perhaps the facility is in compliance. The fact remains, and the reason that we're here is that we have a compliance issue that was identified some months back with respect to meeting the 15-month average on NOx. So the facility is currently emitting NOx at a higher rate than allowed under Rule 1102.2 and as set forth in the current permit. The second finding requires the hearing board to find that conditions beyond the reasonable control of the petitioner requiring compliance would result in either an arbitrary or unreasonable taking. Again, requiring compliance with the NOx limit at this juncture outside the granting of a variance and resulting in shutdown would result in tremendous prejudice and cost and to the petitioner. And so with respect to that second finding, I think the board, the testimony has been presented sufficient that the board can make that finding as well. In terms of, whether there's a benefit to the closing or taking would be without benefit, I think, again, there has been testimony sufficient for a finding in that regard. The testimony today has indicated that to the extent that the engines are shut down, that landfill gas still flares. That landfill gas might not flare at exactly the same percentage as is coming out of the engines, but it's relatively close. And so basically you have a situation that you folks are very familiar with, having dealt with landfill gas issues, where absent operation of this system, you're still going to have contaminants emitting to the environment. We did consider curtailment with respect to the fourth factor, and the issues associated with this, this application of what we will call and have called new technology, although I think that that's a little bit of a misnomer in the context that we've talked about and that you've received testimony on. Our issues would not be solved by curtailing operation. And as mentioned, the landfill gas still would be flared. So number 5 is during the period the variance is in effect that the applicant would reduce emissions to the maximum extent feasible. We've indicated that we're operating engines, I believe it's 1 and 3, at lower loads, so those are not being run at capacity. And Ms. Frank also agreed during the hearing today in response to a question by district council that we would agree to a condition, to be negotiated, but I think the essence of it was agreed to here, that bricks within the system, within the SCR, could be replaced on a more frequent basis to both achieve compliance in the short term, but also to reduce emissions. And the thing that needs to be kept in mind there, and why I made that distinction and inserted that or, is that there are 7 engines, and so nothing happens sort of at one time. Things happen in series. And so with respect to that particular finding, though, Bowerman has reconfigured the engines, and as I said, and so I think that that finding can also be made. Lastly, with respect to the time period that the variance is in effect, which we would ask for 90 days in this circumstance, we will comply with the proposed conditions that have been negotiated with district staff. I think as you've heard through Ms. Frank's testimony and also through district council and staff, there's a very good working relationship. There's a lot of communication that takes place between the regulators and the regulated entity, and that will continue both informally and will also continue formally with respect to the proposed variance conditions. I also want to speak to the procedural issues briefly because I know that that's of concern, and I just want to remind the hearing board that what has occurred here is that we Bowerman Power filed for an interim variance and a regular variance on July 12th. And I think we can all agree, in retrospect, we should have filed earlier, either on an interim basis or an emergency basis, and then we should have sought a regular variance. We didn't do that, and I'm not going to ask for any, there's no excuses associated with that, but it's a simple fact. And so procedurally, after the hearing board, I think appropriately determined that there was an absence of diligence with respect to good cause, we consulted the statute, we consulted with district council, we consulted and coordinated with the clerk, and that's why we're here today for interim coverage. And I think, as the hearing board can appreciate, there's questions concerning the degree to which the facility is out of compliance right now. And we did not want to allow another 14 days to go by before we came before you on a hearing that is still set for August 24th. Instead, we took to heart what was said to us on July 26th, and we're back before you today, 2 weeks earlier than we otherwise would have been. The particular code sections that are relevant are 40825 of the Health and Safety Code, and with respect to the language of 40825, there's no requirement in that statutory provision that compliance needs to be achieved. Now, I will grant you that it's the expectation of the hearing board, and I think in the normal situation, as you heard from in the beta situation earlier, that parties may apply for a short variance and come back having determined that they cannot meet that or short variance, and have come back to the hearing board having determined that they cannot meet the requirements and they need more time, and there's consideration given at that time. And I think the important thing to point out is that 40825 works in conjunction with 40826. And so I would say that we actually expect to come back before you. And it's not that we're speaking out of both sides of our mouth. And I know that for some, you might have viewed the testimony as inconsistent, but I don't view it as inconsistent. I view it as clarifying. And I think the record before you basically supports the finding, if you will, that Bowerman in this particular circumstance is prepared to do what is necessary and has agreed to add a condition so that emissions are reduced and compliance may be achieved. It's possible to achieve that compliance within the 90-day period. Having said that, it's also very true that Dr. Muzio's work and FERCO's work is at a relatively early stage. They only really started on site on July 27th, and we're still gathering information. It's a complicated system. There's not just one engine, there's 7. And so for purposes of what Ms. Frank referred to as a sustainable long-term solution, Section 40826 contemplates that a party can come back to the board, or in the context of just seeking a regular variance, that proceeding will be noticed to the public, and we will have to go through this same process. And I think the other beneficial aspect of the possibility, or some might say probability, that we're back before you on a regular variance is that the interaction that we have with this hearing board is tremendously valuable to us as a regulated member of the community. And I hope that it's also valuable for you. I think one of the things that is very clear is that Rule 11.2 is not an easy rule to comply with. And so we've heard things that, I don't know that we're the canary in the coal mine, but I think that the work that we are undertaking and the granting of the variance to allow us to do that without threat of enforcement is beneficial to the community, it's beneficial to the hearing board, it's beneficial to the district, and yes, it's beneficial to the petitioner. So I'll wrap up by saying that I think that the testimony has established the 6 findings necessary for the hearing board to grant the short variance. I think procedurally, this hearing board is well within its rights to proceed as contemplated by us being here on a short variance today. And it's just not necessary for there to be a finding that the facility will in fact be in compliance in 90 days. I think what you've heard today is that the facility can take more concrete steps, and those steps frankly were developed through the benefits of this hearing board and having the colloquy with you. But it doesn't mean that you can't grant the short variance. And I guess from my perspective, and from Bowerman's perspective, for us to have to come back on the 24th, which we're prepared to do, on a procedural issue at this point doesn't seem to be the best use of resources. We've talked a lot about the cost associated with catalyst replacement and brick replacement and stuff, but I hope it's not, we should all bear in mind too that I come from San Francisco. We have representatives flying in from Pittsburgh, and I know that that's not really an issue, but I think I would just encourage us and say that it's within the rules for the hearing board to grant the petition in the manner that we have asked for, and we would ask that you do so today. Thank you.
Thank you, Mr. Hines. Ms. Reichart, your closing.
Thank you. Well, I think this case took an interesting turn after our break, and to me, it actually seems relatively simple in that we have a fix that can be achieved within this short variance period. And Petitioner says that they, will agree to replace the catalysts, which would bring the facility into compliance while they continue to work on a long-term fix. So from our perspective, we would want to add a condition that requires the replacement of these catalysts to bring them into compliance. And then the variance would last until the point where they have come into compliance. And then they would be required under their permit and under district rules to continue to maintain that compliant state. And it sounds like they know what they need to do to maintain that compliant state while they take other actions to figure out a long-term fix. I understand this is not something that they want to be able to be doing in terms of replacing the catalyst every 6 months to a year. But it seemed like within a year they thought they could have that permanent fix. So if this can allow them to be in compliance while they seek that permanent fix, it seems like all they really need is a short variance in order to order the catalysts and achieve, be able to show that they have met the emission limits. So with that, I would request that we add a condition that they replace the catalysts that they have with the ones that they currently have on site and place an order as expeditiously as possible, but within 7 days or whatever the board deems proper of this hearing date for enough catalysts to replace all of the catalysts in the subject engines. That may need to be tweaked. I just did that off the top of my head. So I would suggest that, and then to me, there is no problem with finding, the 6 findings, and I don't even think we have to address the concern of whether there should be a short or it should be a regular, and the notice concerns, because I think the testimony established that they would be able to demonstrate compliance within the 90-day period. So with that, subject to compliance with the proposed conditions, with that addition, the district is not opposed to a granting of this variance.
Thank you. Board members, anyone want to start the discussion? Because I think that, as Ms. Reichart stated, this case has taken a couple of turns throughout the afternoon, and I'm just not sure where we go from here. Go ahead, Dr. Lerner, if you have something you want to
start this out and ask the question of the board, they can do this. I'm not really sure that they can replace the catalyst and be in compliance. But if they do, once they start to play with the system in part or in whole, they may be coming out of compliance. And the question I have is, they're going to be out of compliance at some time when they're doing this. And how does that work? The second thing is, if they can do this in a week, the argument would be, well, we'll give them 3 weeks to get everything together and be in compliance, and then we're going to let it go? And then what are they going to do? I think it has to have, the truth of the matter is, this is the way I feel. I think, Dr. Frank, I think she said this, and I don't know if she would like to take those words back, that we could take the catalyst and replace them and we'll be in compliance. Frankly, I don't think so. I think you're going to be in compliance for a minute, an hour, a day, 2 days. They're going to be out of compliance. And we're going to start all over again. They're going to come back at us. I think we have to take a little bit more and I like the idea of getting that idea of getting the catalyst in place immediately, because I think that's a good thing. That means that we're acting positively, we're asking them to act positively. But that's just the beginning of this. I think it's far more complicated. And when she kindly enumerated at least 5 things that needed to be done, that's not going to be even in 90 days, because it's trial and error. That's just the way I feel. Personally, I'm in favor of giving them a variance. To me, the question is not giving them the time, not giving them a variance, but how much time should we do? And should they actually be coming back with a more comprehensive view for a regular variance? Okay, that's what I have to say. Thank you.
Thank you. And I actually, if you don't mind, I think you're framing this correctly, because I do think that by asking for the short variance relief, I think that petitioner has put itself into sort of a catch-22 position. Let me start by saying, in his closing, Mr. Hines admitted, I think you phrased it properly, what it is that you're really asking for. And that is, you said you were looking for, quote, interim coverage. And that's the intention behind the request today for short variance. The intention was that the interim variance was denied because of a lack of diligence. Petitioner, rightfully so, wanted to get coverage as quickly as possible. And so rather than waiting for the regular variance hearing, which I do believe, after hearing the whole of the testimony today, is the appropriate relief that you need to request. But instead, essentially, I think what petitioner is trying to do is to take a square peg and fit it in a round hole. And by doing that, and the square peg being the variance relief you want, and the round hole being, looking for, or that being short variance and trying to fit it in the round hole of your problem, is putting you in a catch-22, where either one, when you go over the findings and you say you are or will be in violation, either there is a compliance issue and you need a regular variance to fix it, or you can just put in catalyst and you don't have a problem anymore. And while we heard that second part in the 11th hour of this hearing, I think the weight of the testimony that we received today, both from Ms. Frank and from Dr. Mueller, is that I'm sorry, I'm saying your name wrong, and I apologize for that. Muzio, I'm very sorry, I keep getting your name wrong. Was that it's a much longer term issue for which regular variance coverage is what is required. And I just want to start on that because in my mind, I think this board needs to be highly cautioned against allowing the use of a short variance in the way that is being asked, because we're setting a precedent that I think is very dangerous. Imagine the scenario where every time a petitioner comes before this board and good cause cannot be found for interim relief, instead, they ask for short variance relief as interim coverage. That is not what it's meant to stand for. That's not what it's meant for. So let me go to Health and Safety Code 40825. What it does state to me, and why I believe it cannot be used in this scenario, is in case of a hearing to consider an application for a variance or a series of variances to be in effect for a period of not more than 90 days, not more than 90 days. It goes on to say that the posted 10-day notice is appropriate. Series of variances doesn't just include short variances or emergency variances. It includes regular variances. And when it is different from the case we had this morning, where by the end of the hearing, I was convinced that it is very likely that a correct or a new testing would show that they actually are in compliance and they would be in compliance within the 90 days. I'm convinced from the weight of the evidence, and I'd like to hear from fellow board members, that the petitioner here is not at all likely to be in compliance with emission limits within 90 days. And I just think that, again, they're putting themselves into a bad position by claiming that, as Dr. Lerner, as you were pointing out, it's not a long-term fix. We know it isn't. And we know that they're just at the beginning of looking at the problem. And so nobody really knows what the solution is at this point. And a regular variance is what is required. And again, I would just say, I took some notes. Again, I believe it's a second bite in an interim variance. The interim was denied. The petitioner has continued since denial of the interim to operate the subject equipment. So all of the issues that were told to us, the harms, aren't really the harms. They're going to continue to, if we wait until the 24th of August and have the regular variance hearing, I don't think those harms are going to come to fruition. I think they'll just be possibly sporadically out of compliance. I just want to end what I'm saying by saying I do think this was a helpful hearing to the district. I do think it was a helpful hearing to the board. I do think ultimately this board may determine that a variance is definitely required in this situation and warranted. But I think the intention behind requesting a short variance is for an interim nature, for interim coverage, and that's not good precedent. And it opens the floodgates for other petitioners to do the same. Dr. Lerner.
Okay, I'm not an attorney, but I can recognize to a certain extent the legal arguments that you're making, but also I think we have to argue, I think the point that I want to make is the following. They are sort of at a cutting edge of a problem. Nobody has come before us with this problem, but that doesn't mean it doesn't exist. There's several others, as testimony has indicated, people who are coping with the same kind of problem because of the amendment that 11.02, which became effective 01/01/2017. I think we have to bend a little bit in our thinking about what they're trying to do and help them get started. But do I think they need another variance? Yes, I think they need a regular variance. But I don't want to, I would just like them to get a little protection now and have them come back on the 24th and let us know what's happened in the next 2 weeks. They already have some catalysts there, they can give us some data. I think the FERCO people can provide them with some information, but I do think they do need a regular variance. I don't want this to be a 90-day variance. For me, the question was not that they shouldn't have a variance. I think they basically satisfy barely, if not a little bit more, the 6 criteria. I want them to go ahead and get a regular variance. The only question for me is when they do it.
I want to say this in response. The statement I made, what I'm proposing is not to deny coverage. What I'm merely saying is that we should dismiss the request, the improper request, to use a short variance today as an interim variance without prejudice and allow this to move forward as it should have in the first place as a regular variance. That's exactly the decision we made at the interim variance hearing. We said there was no good cause to give variance protection in the absence of notice to the public. We weighed any harm to petitioner in waiting until the 24th of August. That hearing has stayed on the calendar. It hasn't moved. We already weighed that. We said they can wait until the 24th because they were unable to show good cause in absence of notice to the public. So I don't see where now that posted notice, which is improper, I believe, legally, under the Health and Safety Code, which is right outside the door for 10 days, now allows us to grant that interim coverage, whereas a regular variance would require 30 days published notice. And that's ultimately what we all agree, based on the weight of the testimony, will be necessary and probably granted. I can't speak for the rest of the board members, but it's not just a procedural thing. Notice is very important, and that's why we have the strict guidelines that we follow on interim variances and emergency variances, because notice is important. And insufficient notice isn't good enough either. And I don't think that's the use of short variances that is contemplated in the Health and Safety Code, but that's my thought. It's not that we're denying. It sounds very procedurally technical, but again, bad facts make bad laws and bad precedent. And if you apply it this way for this petitioner because you think, well, they're just coming back on August 24th and it sounds like we should give it to them, then we're opening the doors to give it to every petitioner who uses it in this way. Ms. Byrd.
For me, I believe the variance changed, and so I feel more in a position to, because they will be in compliance before the short variance ends, I feel more inclined, I wasn't inclined before, but I feel more inclined to grant the variance. I think we can make the findings for sure, and if they do come into compliance, which it appears that it is possible for them to come into compliance, and then they're operating, and then they're continuing to do whatever they need to do to fix what they need to fix long term. I think that I can make the findings. I think that I could do that.
Senator.
24 days is the 24th, I think. I mean, 8 more days. But it would come back for a regular variance. That's on calendar already, I think. And they've given notice. There's the proper notice for the regular variance. Is that correct? That's been given?
Yes, proper notice has been given.
Well, I'm inclined to support the chair who says yes, and Ms. Byrd and the doctor, that you grant this short variance, and then that's what before us, correct?
The request is for a short variance.
Yeah,
yes.
Request. That we approve the short variance request that's before us. And then to give you all the time you say you need to replace all those SCRs to make sure they're operating at the time you have your regular variance hearing on the 24th. I think that's the issue that's before us. Also, I'd like to add to that that you're the first one out of the gate in order to be in, to try to be in compliance with this 1110.2. And it would benefit, as you say, the petitioner, but also benefit the district. What we're trying to do here is district-wide. It would be like a prototype, a model that could be used in other areas as well, at your expense, which is okay. You first out of the gate, you got to do it. So with that being the case, I give you some points because you're helping the district as you help yourself. So I'll be inclined to go along with the proposals being submitted by the chair and others to grant it.
Okay, but, yeah. I'll just make my last statements, and then I'm going to ask if anyone wants to go through the findings. I think we'd be granting a short variance on a very disingenuous basis. I think petitioner knows they're asking for interim. I think Mr. Hines stated that they're asking for interim coverage. I think that the...
If I did, I didn't use, if I used the word interim, I used it by mistake in the context of my argument.
Okay.
Yeah,
I understand. Okay. I understand. However, the weight of the evidence, that's why all of us are questioning whether or not we're going to see, we're going to see petitioner again for further relief. And I can bet pretty highly, I think it would be a good bet, that we will. And at that point, I'm not sure what we say, because at that point, we'll have already given the short variance, knowing it wasn't the full relief that was needed. They will have come into compliance for the moment, but requiring the long-term fix that we know they need, they would come back to us, thus circumventing the notice requirement, the correct notice requirements. And I'll tell you, timing does matter, because today we're making the real decision. If we grant the short variance, that's the real decision. We're going through the 6 findings, and it's very likely that we would find the same findings if the regular variance comes before us, however long down the road. And that's why it's important to get the proper notice out for the proper amount of time, and that's what's required by Health and Safety Code. But with that said, it sounds like there are others that may not agree, so let's move on to going through the 6 findings. I don't know if anyone wants to go through that.
Madam Chair.
Senator.
Has been suggested if they come in with those SCRs and then and the inspector goes out and say, well, you're in compliance in 2 days, number of days, that's before the 24th. It's going to look pretty good when you come back, so let's see what you can do. You've testified to that point, by the way.
Ms. Bird, I know you went through the last one. Would you like me to? I can go through the findings.
What I wanted to say was that I need to have that condition first. And I need to have that condition, and I need to know how long. Petitioner has said that they have some catalysts on hand. I need to know which are being changed out, how many are being changed out, how many are not being changed out, when they will be changed out, that kind of thing. So if the parties can come up with something, I would appreciate it, because I need to know that.
Perhaps it would be good to go off the record for a few minutes.
Yes, please.
Okay.
Yeah, but I'm gonna say that, but I can't, since I want them to immediately, I can say no later, immediately, no later than 5 days, I think we do too. No later than 5 days.
Back to school.
And I can say that.
For her to get a call. Get an extra.
What they have there. With all, well, because I want them to immediately change out everything they have. Then I also want them to immediately place an order for everything they don't. So those things need to happen at the same time. They're changing out if they have them. So I don't know if you have
They're calling to see,
how much they have?
yeah,
Okay, that would be helpful, because
Yeah.
then that'll help us craft.
yeah, they knew that, so.
Have you been listening this whole time? Well, I don't think that's come up. Well, the problem is, they use her headsets, but there's no, they have complied with all requirements to obtain that. Well, the problem is that we haven't enforced it. We haven't something that not being enforced. I sat down and I argued with all of them about this, and the result was, well, there's just a contract. So what do? I can't do anything about that. Well, no, we were doing, but as soon as they can show compliance with conditions, which may be in condition. What I was gonna say, before we move to source test. So that should be another condition, that they might have a source test after they've replaced all of them, they have a source test. So, and then, here's the thing.
Hello, how are you?
Because, let's say they start failing, how do we even know? Because they won't be, once they show that, then it's covered, done, unless they can show the ground. So at that point,
Oh, I'm sorry. This is very funny. This guy, he's not even a fruitcake.
Oh, my God. That's nuts. That food looks good on Tuesday. Call me later.
So now it's on to you, that's another time to give me the information I need, and then we'll take that process. And then if they don't find it, then we go on that one, and we just work on getting it certified. I think that's outside of this.
Madam Chair, I just like saying it as the last word to say.
It's a different thing, I think we have to hear evidence about this, they can't, and if it was exceeding, then they're not compliant. I'm so tired. Have I already signed?
on the recommendation.
Did we figure out how many you have on site?
We have enough to distribute probably, if we were going to replace some of the roads, we think enough to get us into compliance. We probably have enough like 3 engines at the
On
site.
site, and then it takes
Yeah.
like 60 days for us to get in the other bricks.
Okay, so if we wrote a condition that said, and is the 3 engines include the one you already replaced, or that's 3 additional engines?
Additional.
Okay, I mean, if you want to draft something, are you drafting something, or are you?
No, I was listening to what you
Oh,
were
okay.
saying.
So if I draft a condition that says you have to replace all of the catalysts for 3 additional engines within 5 days, because those are the ones that you have on site and it takes 2 days?
Word is that we would replace the catalyst through the essentially to get into compliance.
Okay.
We will replace the,
I mean, you could probably say this better than the technical. There were originally 3 roads. Four roads. We could get in compliance to achieve 1 road to 1,000.
Well, that's what I had asked, but it sounded like that wasn't the testimony that you'd presented, because I wanted to know, can you just take the ones you have and say replace 2 for each, and then does that mean you're in compliance?
that's what we're.
And that's kind of what we've been doing.
So how much time do you need to replace enough to be able to demonstrate? Can you replace enough with what you have on site?
We could probably replace several, we have enough for probably all of the engines.
Yeah.
Well,
Would that question is, would that be enough? And the answer is,
Yeah,
no matter what,
yeah, the same.
we need more bricks.
Okay, so we don't have a set, I'm having a hard time crafting the condition without a number. So if you either give me a number, I'll just say all of the bricks you have on
Say 2
site.
engines and then order for the rest of the engines.
So you will but you want to fully replace 2 engines, or you want to do 2 bricks per engine?
No, we want to
We're back on the record, and we're getting dangerously close to our end time of 4 o'clock. So we just received from the district a new condition to be proposed as part of the conditions that are currently on exhibit number 3.
There's actually two conditions.
Okay.
So I didn't number them, they're just, but yeah, so those are two separate conditions.
Thank you. So we will number them separately, and let's call this Exhibit A. A as an apple. Okay. Board members who would like to start our discussion regarding the 6 findings? Anyone? Senator?
I can make a finding. Nobody's surprised. The petitioner, Bowman Power, LFG, LLC, case number 6088-1. The petitioner for a variance, short variance, is or will be in violation of 1110.2. Non-compliance of District Rule 11 is due to the condition beyond the control, reasonable control of the petitioner. The petitioner has to be in compliance with exhaust treatment system, which they cannot predict that they could be in compliance. It's out of their control for various reasons. Requiring compliance would result in unreasonable taking of the property. The closing or taking would be without a corresponding benefit in reducing air contaminants. Given the fact that if you do not extract it from the gas field using these engines, you would have flares that would be emitting an unreasonable amount, or unacceptable amount of gas into the atmosphere. The petitioner for the variance has given consideration to curtailing the operation. However, that would not be in any benefit either, for the same reason that already been expressed. During the period the variance is in effect, the petition will reduce excess emission to the maximum extent possible, feasible, and that they were admitted that they would retrofit the systems with SCR devices as available and have them all in place by date specified by Exhibit A. During the period the variance is in effect, the petitioner will monitor or otherwise quantify emission levels from the source. If requested to do so by the district, and they should request it, report these emission levels to the district pursuant to a schedule established by the district. The amount of emission, I don't have that amount, but it can be inserted. It's my opinion that good cause has been made or established that the short variance requested by the petitioner should be granted. In the matter of...
Wait, before we call for a motion, let's finish the discussion. Thank you, Senator. I just wanted to add to the discussion. I think it's clear where I'm leaning in terms of the short variance, but in terms of the 6 findings, I wanted to mention that in the petition on page 4, there are a number of rules which are listed that petitioner is looking for variance relief from. 3 of those rules do not apply in this situation. Rule 1303A1, Rule 1703, and Rule 1303B2 all apply to the executive officer. They are not emission limits or otherwise that apply to facilities, and so those are not appropriate for variance relief, which leaves Rule 1110.2, as the Senator mentioned. But in addition, petitioner is seeking Rule 203B and 3002C1 with regard to its permits for all 7 of the IC engines that are in question, and in particular conditions number 4 and number 8. As far as beyond reasonable control, I think it's, I do also think beyond reasonable control can and ultimately be found. I think that the petitioner relied upon the, should we stop? Or? I'm just wondering.
I'm so sorry.
It's okay.
They just brought up like they wanted to make a change to the condition, so I was trying to work that out so we could then present it.
Okay. No, it's okay. And it's not that I feel slighted, but I'm just wondering if you feel you need it.
I know,
Okay.
I was trying to let you guys continue.
That's okay. Then let's go ahead and we'll continue. Conditions beyond reasonable control, I do believe that it can be made because I think that they did reasonably rely upon the experts to design the system. But I think what we were seeing is that this system was not properly designed to handle the ammonia slip and the addition of NOx that is inevitable and something that should be known about. But I weigh that against whether petitioner is or should have been the expert that should have known that. Or I think that if the rest of the board members agree, I think it's reasonable to have relied upon the expert that was hired to design it, the system. And I do question whether requiring compliance for the short term would be an arbitrary or unreasonable taking of property. My feeling is petitioner has continued to operate since the interim variance, and I believe they will continue to operate. And so the taking would be, when they're in noncompliance, any fees that accrue from a compliance standpoint by the district. And I'm not sure that's, in my mind, unreasonable taking of property, but I'm sure others will probably disagree. But that's my thought. Otherwise, I agree with, I believe I agree with what the senator had to say in his findings. Anyone else want to add? Ms. Byrd?
I agree, and I think it's significant that it was stated in testimony that there's about 85% of the NOx that will still be emitted as a result of flaring, and that there will be some SOx emitted because there's no control for the flare, whereas there is control on the pollution control equipment that we're talking about. So I think that that is significant in itself. Let's see. I also wanted to add that petitioner has in some way a little bit of curtailment in that they have reconfigured the engine so that 1 and 3 are operating at lower loads while they're still assessing the situation.
Before we move forward with any kind of motion, is there a change that is being requested for the proposed condition on Exhibit A?
Yes.
Okay.
So if you, on the top condition, the top paragraph, on the 1, 2, 3, on the 4th line, the sentence beginning with the word petitioner shall install, we would insert the words a sufficient number of the ordered SCR catalyst bricks, and then insert the words to come into compliance with district rules. And that's it.
And what is being sought in terms of, is it, and I want to know what's being sought by petitioner and what's being agreed upon by the district in terms of the term of the variance that's being requested. Is it the full 90 days? Is it 90 days or until compliance is achieved, whichever occurs sooner? What is it that's being sought and agreed upon?
90 days or 90 days until compliance is achieved.
And the district is not opposed to 90 days or until compliance is achieved,
Whichever is sooner.
whichever is sooner.
Okay. And with that, Senator, did you want to offer a motion?
I move that in the matter of Bowers Power LFG LLC, address 11002 B Canyon Access Road, Irvine, California, 92602. Case number 6088-1. I move that we grant the short variance commencing today by the approval of this variance request and continue until, is that until the 24th next hearing or beyond that point?
It would be, the request, if you so move, would be for 90 days or until compliance is achieved, whichever is sooner. Compliance with district rules is achieved, whichever occurs first.
Add that to the motion. That's the motion. And we also want to amend it, I'm sorry, after Exhibit A, on the fourth line down, after it says shall install, insert sufficient the number of catalyst bricks to come into compliance with rules.
District rules. So it would
District
read,
rules.
petitioner shall install a sufficient number of the ordered SCR catalyst bricks to come into compliance with district rules within 5 business days, et cetera?
Yes.
Okay. And Senator, do you incorporate thus into your motion Exhibits 3 and Exhibit A as amended?
So incorporated, yes.
Okay. And we should find numbers for those. You want to insert Exhibit A probably soon. I would suggest perhaps 2 and 3, and then renumber after
Just
that?
as because condition 8 refers to other numbered conditions, so I would suggest we do it at the very end as 10 and 11. And if not, we'll just have to renumber some other.
That's fine. I think that's probably cleaner.
Yeah.
Senator, would you like to number them 10 and 11 and then renumber 10 and 11 as 12 and 13?
I'm trying to repeat that.
Would you like to insert those 2 provisions or conditions on Exhibit A as numbers 10 and 11 on Exhibit 3, and then renumber what currently is 10 and 11 on page 2 of Exhibit 3 as 12 and 13?
So ordered.
And then, just a couple other questions, Senator. Is your motion for the equipment that is listed on pages 2 and 3 of the petition in number 6 on the petition?
Page 2 and 3, yes.
Okay, and is it from the rules 1110.2, 203B, 3002C1, as specifically applies to the 7 IC engines conditions number 4 and 8, oh, and 26. I should make sure those are all correct. And only as concerns the NOx emission limit.
Yes.
Okay. And I'm sorry, did you say what the expected excess emissions are?
I did not specify.
Okay, so on page 7 of the petition, number 19, excess emissions are anticipated to be 130.3 pounds per day of NOx. Is that to be added to the motion?
Yes, so
Okay.
specified.
Thank you. Is there a second to the motion? No second? Anyone want to second the motion? Dr. Leonard? Ms. Byrd? Dr. Leonard?
Ms. Byrd, second.
Yes, I second.
Okay. Motion is, there is a motion, there is a second. I'm going to just reiterate in discussion that I, again, do not believe this is a candidate for short variance relief. And any other discussion on the motion? Okay. Oh, yes, Dr. Lerner.
I want to be clear. Is the motion for 90 days or till the 24th? Because the senator said the 24th.
It is for 90 days or until, what did we say? 90 days or until compliance is achieved, whichever occurs first. This is not an interim. This is a short variance being granted if it's voted upon. Any other discussion? Senator?
I believe it was stated that when they retrofit the system with SCRs, they could do that within a couple of days. They'd be in compliance.
And the new conditions 10 and 11, as so moved, would be to install the SCR catalyst bricks currently on hand as soon as possible, but no later than August 17, 2017. The testimony, I understand it, is that there are not sufficient number for all 7 engines. So condition 10 then goes on to require the ordering of additional SCR catalyst bricks as are necessary no later than August 17th, and then to install those within 5 business days of receipt. But since we don't know when that will occur,
Okay.
that's why the 90 days or until compliance is
Understood.
achieved.
Or sooner, okay.
Okay, any further discussion? Dr. Lerner, how do you vote?
I vote aye, and I'm happy to do so, but I'm doing this, I just want to explain part of my vote. My vote, I'm not really keen on the law, and I understand Ms. Prusak's argument, but I am keen on the fact that we are not stepping in, we're not changing the law or playing with the law, but we're just trying to help out a company who is in the middle of something that nobody else is currently doing, or maybe 2 other groups are doing. And the reason why I want to vote for this is because I want to cut them some slack and then hold their feet to the fire that they produce. So I vote A with that caveat.
Thank
so to
you.
speak.
Thank you. I vote no. The motion passes 3-1. And again, I think we are confined to what is required in the Health and Safety Code. And I hope we do not see an onslaught of petitioners using short variances for interim relief. With that, we're done with the hearing. Board members, any other business? We are adjourned. Thank you.